No problem. You got a minute. All right. So the first one we're doing is Mewborn. Okay, I think we're ready to go. Is Mr. Mewborn on the screen?
That appears to be him, Your Honor.
Can you raise your hand, Mr. Mewborn? Great, so you can hear me. We're going to start once the court reporter comes back. He had to take a quick break, and then we'll get going. And Mr. Moniz, you've got the witness you need. I see her on the screen.
Yes, sir.
Great. So we're doing position 2 first. You ready? Ready. Great. All right. This is position 2 on our bond calendar. It's 20 CP 195529. It's State versus Mr. Mewborn, Mewborn. Mr. Mewborn, you are charged with murder, aggravated assault, and possession of a firearm during commission of a felony. And your attorney, who is on this Zoom call, Mr. Moniz, has filed a motion for bond. I'm Judge McBurney. I'm a Superior Court judge who is connected to your case for bond purposes only. I'm presiding this week, and it means I handle the bond calendar for certain classic cases that includes your case. So all we're doing today is talking about bonds. Mr. Moniz is going to tell me why you ought to get a bond and what that bond should look like. Mr. Pinion, who is someone with the district attorney's office, a prosecutor, is going to share with me the state's view about bond, and then I'll let you know what's going to happen, and we will go from there. If in the future you still have not had your case indicted, but there is an additional question about bond, the case needs to come back to me. I will have this case for bond purposes unless and until the case is indicted. I think that's it. So, Mr. Moniz, why don't you get us started, please?
Okay, Your Honor, obviously these are different times and we're doing these presentations a little bit differently than we normally would. I generally like to do these with a PowerPoint presentation, but I'd like to call the witness first.
Okay.
All right. Do you want me to swear in the witness or do you want the court reporter to do it, Your Honor?
So you should do it. This is a witness who you want to have give sworn testimony, or is this a witness who is going to vouch for Mr. Mewborn's character, et cetera?
Character and place to live if he's released.
Okay. She doesn't know anything about, she was not present for these allegations. She's not a fact witness.
Not in any way.
All right. You don't need to swear her in. I'm happy to hear from her. And it's fine for Mr. Pinion to ask her some questions, but she does not need to be under oath for what she's going to share with us.
All right. Fantastic. Thank you. Ms. Hightower, can you hear me?
Yes, good morning.
All right. Would you please tell the judge your full legal name?
Lakana Monique Hightower.
And how do you know Mr. Mewborn?
He's my fiance.
And how long have you been engaged?
We've been engaged since April 2015.
And how long have you known him in total?
For about 7-8 years.
And have you been in a relationship with him that entire time? Dating
Yeah.
before being engaged?
Yes.
Okay. Is it your opinion that if released on bond, Mr. Mewborn will abide by any conditions the court sets for him?
Yes, he will.
Will you help ensure that he makes it to court if he needs a ride?
Yes, I will.
Um, where will he reside if released on bond?
At my home here in Georgia,
Okay, and where is that?
in Fairburn, Georgia. Should say the exact address?
Hold on.
You don't need to share the exact address right now. I'll need to get that from Mr. Monas if I'm going to be setting a bond for Mr. Mewborn, but it's helpful for me to know it's in Fairburn.
Yes.
Yes, correct.
Okay.
And that's in Fulton County.
Correct.
Is that where Mr. Mewborn lived at the time of the incident?
No,
Where did he live at the time that this incident occurred?
in Jonesboro, Georgia.
And how come he no longer lives there? Other than being incarcerated, is there a reason that he no longer has that address?
Yes. Yes, it's he can't live there. He can't go there. It's just dangerous right now.
What happened at that address that makes you think it's dangerous?
A bunch of guys ran up in there and took everything out of there and threatened everybody.
Okay. Has Mr. Mewborn been threatened with bodily harm?
Yes.
Do you know who is threatening him, or is it more than one person?
I don't know these people, but it's more than one person.
Okay. All right. Thank you, Ms. Hightower.
Mm-hmm.
Mr. Pinion may have some questions for you, or he may not.
Okay.
Mr. Pinion, do you have any questions for Ms. Hightower?
Yes. Ms. Hightower,
Yeah.
did you know the defendant was arrested in New Jersey?
Yes, I found out the morning that it happened.
Okay, so you didn't go to New Jersey with him?
No,
And do you know why he went to New Jersey?
that's where we're from. Our entire family is back home in New Jersey. No one's here but us and the children.
Okay, and y'all are at
So
a
we're
new.
both from New Jersey.
All right, that's all, Your Honor.
Mm-hmm.
Ms. Hightower, I've got a few questions. So I'm confused if you two are engaged and have been for many. Do you have kids together?
Yes, we have a 8-year-old son.
Okay. And the son lives with you?
Yes.
Why was Mr. Mewborn living in Jonesboro when you were living in Fairburn with your son?
We were living together in Riverdale and our lease had ended. And I was in the process of buying a home and I was staying with someone while I purchased a home. So in the meantime, we all couldn't stay with, my girlfriend. So he went and stayed somewhere else. But I purchased my home here in Fairburn.
Okay. So you own the home you're in.
Yeah.
Do you work?
Yes, I do.
What do you do?
I'm an HR coordinator at a behavioral health facility.
Okay, great. And Mr. Mewborn going to New Jersey, how often does he go to New Jersey?
We normally go, our entire family is in New Jersey. We're the ones here. So, we'll go if it's like a birthday, celebration, holidays, things like that.
Okay, except during COVID, you're probably not going to New Jersey a lot.
Right.
Okay, all right, thank you. Mr. Mewborn, I forgot to ask you an important question at the beginning of all this. You are at Rice Street right now. Mr. Monas is not with you. He is in a separate location and you're not here in court. Are you comfortable proceeding remotely with you at the jail and not being here in the courtroom? So I can't hear you. I don't know. It's not muted.
Yes, I'm fine.
Great. I could hear that. And are you okay with the fact that Mr. Monas is in a different place than you are?
Yes, I'm
Okay, great. Well, we'll keep going. So, Mr. Monas, it was helpful to hear from Ms. Hightower. What do you want to add?
Your Honor, also, I did want to add the reason why he was in New Jersey was for a milestone birthday celebration for, I believe, his mother or his grandmother. So he was up there for a birthday celebration. The first he had heard about the warrant was when he was detained on the warrant. He and actually was told that it was aggravated assault. He only found out it was a murder charge at the extradition hearing. I'd like to go through my PowerPoint presentation briefly, if you don't mind.
That's fine.
Now, I'm not super proficient at Zoom, so I'm going to do my best here, but it might be a little clunky. Obviously, Your Honor, this is a very serious case. It's a murder case, but the facts, I don't want, obviously bond, the primary consideration with bond is will he show up at court and will he be a danger to the community? But this was a sudden eruption of violence outside of a club. The situation, there was some back and forth between Mr. Mewborn and a female patron of the club. And then her boyfriend, I believe it was her boyfriend, took exception to it. And that's when this situation really took a violent turn. Mr. Mewborn, my understanding is has no significant history, no significant criminal history, no reason to believe that he's violent. And this is just a sudden eruption of violence outside of a club. He's resided in Georgia for 6 years. You've heard from Ms. Hightower where he'll reside now that she's purchased her home and that she's known him a long time. They have a kid together. His roots are here, even though he has family in New Jersey. He waived extradition to be brought down here. Now, in full disclosure, he didn't waive at his first opportunity because my understanding is that's when he found out that it was not aggravated assault, but was in fact a murder charge. But once he had a good understanding of what the case, what the parameters of the case were, he waived extradition and came down here to face the charges. He has no significant history of violence, and any concerns that the court has about Mr. Mewborn can be addressed through less restrictive means than incarceration, such as an ankle monitor or curfew. But Mr. Mewborn is being threatened extensively with bodily harm, including rape and death. And I'm going to show you just a selection of a couple of the Instagram posts and tweets that he has received. Apparently, the alleged victim was a member of a gang, and certain of his associates have been threatening Mr. Mewborn's life. I'm not going to read these because they're pretty vulgar, but this is obviously clearly indicating that the alleged victim had gang ties that extend behind the walls of the prison in all 50 states and threatening Mr. Mewborn with death. This particular tweet is threatening Mr. Mewborn with rape. And this is saying that, the next time his relatives will see him will be at his funeral. And the reason why this is more serious than most, because there's oftentimes threats. Mr. Mewborn was recently severely attacked and has 2 broken hands. So while he's in jail, he's essentially defenseless. Mr. Mewborn, will you hold up your hands, please? His fiance and his child are here. He does not pose a risk of flight. I understand that he was, apprehended on a fugitive warrant in New Jersey, but he was unaware of the charges. And when he became aware of the charges, he did not fight extradition and came down here to face the charges. There's no risk of intimidating witnesses that I think obviously it's a murder case, but there are witnesses involved in the case. We plan to contact them, for interview purposes, but he has no reason to have contact with them and would be happy to have a bond condition stating that he has no reason to contact them. Additionally, Your Honor, it's quite difficult for anyone to get any sort of access to an attorney during COVID. We have video calls that are not monitored, but the connection is very poor. It's very hard to hear, and it's very hard to properly prepare for a trial. This is a very serious case. Any conditions that the court would consider setting, my client would agree to. Additionally, there are health risks to him when he has 2 broken hands, being able to clean himself in a jail that has COVID implications. I would ask the court to consider releasing him on a reasonable bond of $50,000. And I'm going to try and stop sharing my screen. this time, but I'm not quite sure how to do that. With any conditions the court might set to assure that he shows up at trial and stays out of trouble while he's out on bond.
All right, you handled the PowerPoint very well. Ms. Hightower, I've got another question for you. Were you at the club the night of this purported shooting?
No, sir.
Okay. Mr. Pinion.
Thank you, Your Honor. Your Honor, the state opposes bond. We believe he's a risk of flight. We believe that's why he went to New Jersey, and he's a risk of further felonies, and he's a risk to intimidate witnesses. Your Honor, this started with the defendant being kicked out of the club and in an argument with another female there, and the female is afraid of him, that had reported that he had pointed a gun at her. And the deceased was the female's boyfriend. After he heard about what had happened in the parking lot, he went to defend his girlfriend, and the defendant shot him multiple times and then fled the scene, and I guess finally ended up in New Jersey. Your Honor, the defendant does have a violent history, contrary to what the defense just stated. He actually has been convicted in New Jersey. I'm looking at his NCIC. And on June 10th of 2013, he was convicted of felony resisting arrest and robbery, and received jail time and probation for that. Here in Georgia, he also has a record. It started in 2014. He was convicted of DUI in 2014, October 14th, 2014. Then I believe the victim here is Ms. Hightower. On April 1st, 2015, he was arrested for family violence battery, and he was convicted of that on October 2nd, 2015. And he actually pled guilty to 2 counts of that. Received 12 months probation. 2016, he was arrested for driving with a suspended license, and he pled to that. 2017, again arrested for driving with suspended license. And criminal trespass, 2018. Let's see. July 12, 2018, he was arrested again for family violence, and he was convicted of that October 1st, 2018. And he received 81 days in jail for that. I believe Ms. Hightower was the victim on that one as well. And then earlier this year, February 23rd, 2020, he was arrested again for another battery, and that case hasn't been disposed of. So he has a history of violence, and he is a convicted felon, so he should not have had a gun out there. And his ties to this address appear to be zero. He's never lived at this address before. We never heard any evidence of him having a job. I wouldn't expect someone with that record to have a job. But I'm not surprised there are people threatening him, given that he killed somebody in front of numerous witnesses at a club parking lot and then left the state. So we believe he has a history of violence, and he's arrested in New Jersey where he has a criminal record, and we believe that he is a very poor candidate for bond.
Mr. Pinion, I have a couple quick questions. what was the timeline from the shooting to the arrest in New Jersey? Was that months apart? Was that days apart?
Your Honor, Odyssey keeps crashing on me. This occurred, the murder occurred on September 14th, 2020. And what we've heard of how the defendant did initially fight extradition, it had to have been fairly within a month. I couldn't tell you.
Your Honor, I can tell you, and that's not correct.
Okay.
November 3rd, he was arrested November 3rd in New Jersey.
Okay.
So a month and a half.
Several months later.
And Mr. Pinion, question two, what evidence, and just, we're not litigating the case now, but you are relying heavily on, look, Mr. Mewborn was all the way up in New Jersey, which is very far from Fulton County. So it's flight. That's what you want to argue. And Mr. Moniz has said it was a birthday. That's why he was up there. And it sounds like it wasn't just 2 days later, but it was a month and a half later. But what is it about the evidence that leads you to believe that Mr. Mewborn would know that there may be folks looking for him, meaning law enforcement looking for him? It's one thing if this is a stranger on stranger ID and Mr. Mewborn's defense is going to be, I wasn't even at the club, I don't know what this is about. Then the fact that he's in New Jersey is somewhat unremarkable. But if this is a case where he knew, I mean, it's just the defense is not going to be he didn't shoot this guy. It's going to be self-defense or something else. Then it is much more remarkable that he's in New Jersey. And it's nice that he didn't fight extradition for aggravated assault. He also didn't say, I did the shooting and I ought to let law enforcement know because it was self-defense. So tell me what this thumbnail sketch connects Mr. Mewborn to these allegations. Is it all on video and he's wearing a shirt that says Mewborn on it, or people describe a guy in a gray hoodie and someone has surmised that that's Mr. Mewborn?
No, Your Honor, they figured out who he was right there that night. He goes by the name Meek. This was a nightclub that the owner, the security guard knew him. The female he was in argument with, it was about a car in the parking lot and borrowing the car, had known him for 6 months. She ID'd him immediately from a lineup. A individual came up to the police, it's on body cam, was able to give the information, the tag number of the car, and the information that was the police were able to pull up his photo immediately.
Okay. Second, last part in this area, the victim in this case, somehow this was rattling around as an aggravated assault case initially, or at least up in New Jersey, and not murder. And I noticed even on the calendar, the first count is aggravated assault, not murder, which is peculiar. Did the victim survive for a while? So Mr. Mewborn, if he was involved with this, might reasonably have thought, if shooting in self-defense, I just shot the guy in the foot, so I'm going to go on my way to get out of this dangerous situation. But I shot him in the foot, not 18 times in the head, or whatever you understand the facts to be.
Your Honor, he was not shot in the foot. I don't know how long he lived. But this was a shot to the torso, and I could not tell you, I don't want to mislead the court. I don't know that there was an aggravated assault upon the female witness that led to this. The deceased came out of the club once he heard the complaint and of the gun being pointed at his girlfriend. So that's very hard to argue self-defense, especially when none of the witnesses, the security guard, the owner of the club, or anyone has said that the victim had a gun. I'm not just relying on flight, Your Honor. The defendant is a convicted felon that should not have had a gun. Of robbery, violence on a police officer.
I got all that. Okay. Let me ask Mr. Summerall, is there anything that the victim's family wants to have shared in this setting?
While our office has managed to reach the family before, back on, let me check the exact date, back on the 2nd and the 3rd of this month, unfortunately, they stopped responding to us around about the 10th. I myself have tried to reach out to them this morning and have received no reply. They did not provide any kind of opinion on bond when they were
Okay. Thank you, sir. Mr. Monis, as the movant, anything you want to say in summary?
Yes, sir. But I did want to address that last round of questions between you and Mr. Payne.
Sure. That's part of what you're going to say in summary.
Sure. My understanding is that there was a shootout, and Mr. Pinion's opinion about, the viability of a self-defense argument, the report that I have, and I obviously have a lot less material than Mr. Pinion at this point, but the report that I have from the state says that the alleged female victim, although he's not charged with aggravated assault on that person, left the confrontation and went and got a gun and went and informed her boyfriend. And then my understanding is she and her boyfriend came back out and a shootout ensued at distance. This was not whatever the court's perception is. I think this was a shootout at distance, and Mr. Mewborn fled on foot. And there's absolutely no evidence, and I think Mr. Pinion will have to agree with this. He can present no evidence at this time that Mr. Mewborn had knowledge when he fled that anyone had been shot, let alone killed. And as I said, several months later, he's in New Jersey and he's picked up on a warrant and told it's for aggravated assault. But prior to that time, he had heard nothing about anyone being injured. So I think bond is appropriate. Whether he's ultimately convicted of these charges, we'll see. But there's no reason because he went to a birthday party. And Your Honor, not to belabor this, but I have pictures of the birthday party if the court would like to see them. He was up there for a birthday party. He was picked up on a warrant, found out the charges, came back down to face them. And, it's a little flippant to say he has no connection to that house. A fiance and a child is a connection to a house. So that it's a new residence for sure, but it's a residence in Fulton County where his family lives. So, and he does have a job. He's a barber, and obviously he'll have to heal his broken hands so that he can work. But when he has the use of his hands again, he intends to work as a barber.
Got it. Okay. And I want to be clear. We are, to your point, Mr. Monis, we're not litigating the case, and I'm not relying on the state's version of events versus yours. It's just helpful to understand how a case comes together. And it doesn't sound like this is going to be a case involving a bunch of strangers surmising that Mr. Mewborn's picture in a 6-photo lineup matches the person that they saw in the dark for a split second. It's just helpful to understand that context, but I'm not concluding self-defense, not self-defense, shootout, not shootout. That's not the purpose of a bond hearing, but certainly I need to appreciate the seriousness of the situation in which Mr. Mewborn finds himself. All right. Well, I appreciate everyone's input. Ms. Hightower in particular, I appreciate you taking time to dial in. It sounds like you and Mr. Mewborn have had a bumpy relationship over the time, but it says a lot that you are dialing in to speak on his behalf. And clearly you two have been in a relationship for quite some time. Mr. Mewborn, I am not going to set a bond at this time. I think that you have some ties to the community. Clearly, you have ties elsewhere, ties that even in the peak of people not traveling around the country were strong enough that you ended up in New Jersey. Of course, I don't know how long you were in New Jersey. I don't doubt that someone was having a birthday at some point after September 14th up in New Jersey, but no one has shown me that you didn't get there on September 15th and had been there until November 3rd. And conveniently for you, one of those days between September 15th and November 3rd was the birthday of a relative. But not many folks are moving around the country these days just for a birthday. So I'm concerned about my ability to keep you in Fulton County. And I don't know that there is a sufficient set of conditions that I could impose. Sadly, and this isn't your fault, but the consequences affect you. We have had a rash of ankle monitors thrown into the garbage can, and folks deciding to go their own way. So the old ankle monitor isn't the magic solution it used to be. And I'm not going to rely on it in this situation. I am concerned for your safety. I don't know what's going on in the jail there. I suspect you are going to be kept in a safer space in light of what happened to you, and I'm sorry about what happened. The fact that people sent text messages because someone close to them was shot and killed isn't all that remarkable, unfortunately, in these situations. Shootings at clubs and lounges often result in friends of the victim really wanting to get the person who they think shot their friend. So I hope that you stay safe. I suspect that you are more likely to remain alive where you are than if you were out on the streets, whether it's in Fairburn or Jonesboro. But for now, you're going to stay where you are. I keep saying for now because I invite Mr. Moniz to renew his request. He didn't speak to it, but he did have a slide that highlights the fact that things are moving more slowly, or at least they have been moving more slowly because of the pandemic. That didn't prevent you, Mr. Mewborn, from going all the way to New Jersey. But it has prevented us from having jury trials. We intend to remedy that. In fact, we have a jury trial calendar set for just a few weeks from now, January 11th. It may be postponed by a few weeks, but we are bound and determined to get the wheels of the criminal justice system turning again for the very real reasons Mr. Moniz cited, that folks are sitting presumed innocent in jail for an extended period. So we have a grand jury in session now. They're going to take a brief break while a new district attorney gets herself into position. Then the grand jury will be back in action. I suspect your charges will get indicted and we'll be able to move your case along. If that doesn't happen because the vaccine doesn't pan out and things move more slowly, I am confident Mr. Moniz will get us back together again and we can talk more about why bond might be appropriate, not so much because the things I've just talked about have changed, but because you're stuck, you haven't been indicted, and we need to move things along. So for now, I'm denying the motion for the reasons that I explained, but Mr. Moniz, you know how to get back in front of me if that's what we need to do because the case has not been indicted. Okay?
Thank you, Your Honor.
Thank you, everyone.
Your Honor.
Mr. Summerall.
I'd like to make an apology to the court. I was sent this last Friday an email from another advocate who had received a message from Miss Brooks, one of the family of the victim in this case that just ended, where she did state that she wished for Mr. Mewborn's bond to be denied.
Okay, we'll make sure that gets in the file so that if there is a second round of this conversation, we get that, okay?
I will.
Thanks. I think so. I just need a second to figure out how we're going to do all that. Boy, it is going to be a busy morning. Ms. Nelson, the WebEx is for 9:30, is that right?
Yes, and the parties are online waiting. So,
okay.
So that you know.
All right. Ms. Singleton, I noticed that you have appeared. Is Mr. Johnson, oh, it says SB 440. So he's a juvenile. And we'll need you to be plugged in when we have Mr. Johnson's hearing.
Yes, Your Honor. Good morning.
Good morning. All right. So are you Mr. Johnson?
Yes, Your Honor.
Okay, Mr. Johnson, we're going to take a quick break. I'm covering for another judge, and I have to actually get off the Zoom. I'm going to get your lawyer in the mix here, and we will get you and your lawyer together, and then I'll come back in. So hold on a sec. Hey, Mr. Wallet, good morning.
Good morning, Judge. How are you?
I'm well. I have to do a WebEx. I'm covering for another judge as well, and they've lined something up at a state facility. So I'm going to need to do that in just a second. Who do you need, if anyone, from the waiting room to join us? And then I'll patch back in as soon as I'm done with the WebEx.
Do you want my list of who's on? Is that what you're
Yeah,
asking?
so I can get them in now.
Okay. So there should be Patrice Johnson, Prosper Johnson. There is Ashley Johnson, Sean Walton, Ben Hammonds, and Veronica Dallas. I believe all of those were on when we originally.
All right. Yeah, Ben Hammonds has been real persistent. I have moved him in the waiting room about 5 times, and he keeps leaving it and coming back.
I think part of it is not everybody is versed in Zoom, and so I think folks are confused of what's going on or whether they're making an error kind of thing.
No problem. So I've got one that says Edward's iPhone. Any idea?
Not that I'm aware of. I'll check with Patrice, my client's mother.
Well, she's coming in right now.
Okay.
So I assume Patrice's iPhone, that's your client's mom.
Yes.
So the other names in there, we've got Edward's iPhone, just a plain old iPhone, Veronica Dallas, and Coach Sean Walton.
Yes. So
Any,
Sean Walton and Veronica Dallas are with me. I'm not sure of the others.
okay. So the coach is in, Ms. Dallas is in. And you can check with mom to see if those other 2 need to come in. I'm going to actually pass the control over to Ms. Nelson because I have to leave this call in order to do the WebEx. But I will pop back in as soon as we're done with the WebEx.
Okay. No problem. I appreciate it, Judge.
Thanks. All right, let's try the WebEx. I think that'll just be on this device. Hoo-wee. All right. Yes. Interesting. It's showing the back of. Oh, well, take a break. Well, because it's Judge Carnesale's case, so they probably mind. Oh, I don't know if she can hear me or not. She's stuck, probably straddling the two.
I can hear you, Judge.
Okay. Oh, yeah. Are you able to mute?
I can't. I'm trying to mute
No,
everyone.
no. Mr. Forte will take care of muting the Zoom from our end.
Okay, okay, thanks.
Any idea how to switch the camera?
Prosper. Help me. See, I told y'all one right. I'm supposed to see. Help me. Help me. You do what? So I'm supposed to be in a gallery to see. Let me make sure I put on silent. Man.
We're gonna break. We ready for position number 6.
He's kind of like a young uncle. He's been like my big brother. He is my brother's, my father's brother, and we've kind of had like a really close relationship growing up because of his age. He's the youngest of 5 siblings, and he's always been there for me no matter what. In terms of the rough years of high school, he's always had my back, and he's always been there for me. When he was younger, he got into the wrong side, of town, wrong crowd. I know that you're probably nervous, one, being courted, and then you're suing a family member that you love. So she's suing you, she has this relationship with you, you have this relationship with her. This is all about parking tickets. What's going on? Well, I've been there for her from day one.
Ooh. Are we on a brief intermission?
Yes, we are. We are on an intermission.
Okay, thank you.
Deidre?
Yes, sir.
Hey, it's Brett. Do you know about how long the break will be?
I don't know. He's on another matter. So
Yeah. Okay, thank you.
do you want me just to you want me to send you an email when he comes back to the bench?
Yeah, I'm my computer didn't I have to use Zoom on my phone, so I wanted to make a phone call. So I was gonna do that, and I didn't want him to come back and me not be here.
Well, I can shoot you. Do you have your computer on that I can shoot you an email and
Yeah.
you'll see it? Okay,
Yeah.
I'll do that when he gets back.
Okay, thank you.
You're welcome.
Bye.
Hello, Ms. McCauley.
Hi, Judge.
Did your UPS package arrive?
Did.
Excellent.
Unmuted. I will unmute. I know. I'm supposed to unmute.
All right, I think I'm.
Issue with one of the computers, I think, so I'm not even.
Are we okay?
This one came and fixed it.
All right. Ms. Nelson, can you hear me?
Yes, sir.
Great. Can you give me some hosting authority back again, please?
Okay, let me see.
Thanks.
Where.
So for everyone on the Zoom call, thank you for your patience. I was magically transported to Burris State Prison for a while, and someone pled to 3 cases. So Judge Carnesale owes us all that half hour you've been waiting. That was helping her out. We are going to turn in just a moment to the bond proceeding, once I grab my calendar back, involving Mr. Johnson. That is where we paused. Mr. Wallach, did we get into the active room, all the folks you need? We're not on the record.
Yeah, yes, Judge, I believe so.
Okay. Ms.
Judge,
Nelson, have you been able to make me the,
I'm gonna have to sign off because I don't see you on.
You know what? I'm right here. I'm listed as you. So give me my name back.
Okay.
And let me start the video too. That would make it easier for you to find me. Hello.
Okay.
Sorry about that. Excellent. There are some of you on this call who have cases later on in the calendar. I'm moving you into the waiting room. Don't panic. So Mr. Adams and a few others, I'll get you out of the waiting room, I promise. We're just trying to reduce congestion on the screen. So if you're put in the waiting room, it's not personal. Ashley, are you on for the Jeremiah Johnson call? Don't know. Okay, put you there. Is Brandy on for your call, Mr. Wallach?
Yes.
Yes, Your Honor.
Great. Okay, I think we've got who we need. Mr. Johnson, thank you for your patience. Can you unmute for a sec? Great. We're going to get started with your bond hearing. We're going to go on the record right now. This is 20 CP 195037. Mr. Johnson, you're charged with murder, armed robbery, and aggravated assault. And all we're going to talk about today is bond. Your lawyer, Mr. Wallach, has filed a motion asking that I set a bond. I'm Judge McBurney, to formally introduce myself. I'm handling your case only for bond purposes. Until your case is indicted, anytime there's a question about bond, I'll be the one working through that. Once your case is indicted, if it is, it will be assigned to a judge randomly. That could be me. It will likely be someone else. And then that judge is the judge with whom you'll be working and Mr. Wallach will be working to talk about bond. So you may meet a different judge down the road to talk about bond. But for now, it's me. And that is all we're going to be talking about today. I need to make sure, Mr. Johnson, that you are comfortable going forward where you are. You are at an RYDC. You're not here in court. Is that something you're okay with doing?
Yes, Your Honor.
Okay, and Mr. Wallach normally would be by your side to have these conversations, but for reasons I think you can understand, he is somewhere else. You can see him, you can hear him, but he's going to be appearing remotely. Are you okay with that?
Yes, Your Honor.
Okay, all right. Then Mr. Wallach, if you want to get started, I am ready to listen.
Thank you, Judge. Let me give you a little bit of background about my client, Jeremiah Johnson. He is 16 years old. Excuse me. He is born and raised here in Atlanta. Prior to being detained, he was living with his mother, Patrice Johnson, who's on this call, and his older brother, Prosper Johnson, who I believe is either on this call or on through his mother, and their dog. He has two other. Prosper is a triplet, and his sisters, Ashley and Brandy, both live in Atlanta. They are on this call as well. His parents are separated, but his father, Prosper, is also Prosper Johnson, lives in Atlanta, is present on this video. He also has, in addition, aunts, uncles, cousins, all in the Atlanta area. Everybody's local. His mother, Patrice Johnson, is employed with the City of Atlanta for the Vehicle for Hire Enforcement Division. She is a supervisor there and has worked for the city for 27 years. Mr. Johnson, prior to being detained, was attending McNair High School, is in the 11th grade. Obviously, with the pandemic, he was attending virtually. Mr. Jeremiah usually plays sports all year round. Obviously can't be doing that now. Since he has been at Metro, he has continued his classes. He has voiced concern about part of wanting to get out on bond is so that he can not fall too far behind. Jeremiah was the student of the month for November at Metro, which he shared very proudly with his mother and with me, and was just notified that he made the honor roll. His mother has recently moved. They were living in the Decatur area. They will be living in the Stockbridge area. So if he is released, he will either attend school virtually, continuing through DeKalb County, or will attend either in person or virtually at Stockbridge, depending on what is going on with the pandemic and what can be accommodated at that time. In terms of the incident itself, the date of the incident is October 2nd of 2020. The information that I have and will relay to Your Honor is through the lead detective, Detective McClure, what he relayed to me directly, as well as what was proffered by the state at the bond hearing for Jeremiah's co-defendant, his cousin Joshua Witherspoon, who is 19 and who is in custody at Fulton County Jail. Joshua Witherspoon's bond hearing was held in front of Judge Russell, I believe on or about November 10th of 2019. I'm going to work a little bit backwards here, and I think you'll understand why in a moment. So on the 2nd, Jeremiah and Joshua Witherspoon reported to police that there had been a shooting, that their car, Joshua Witherspoon's mother's car, had been shot up. They notified police. Police asked them to go back to the scene. They responded that they were concerned for their safety going back there, and they were asked to come down to the precinct, which they did, each accompanied by their respective mother. They gave a statement voluntarily to Detective McClure. They were released by Detective McClure, and then they were contacted on October 21st. Detective McClure contacted each of them and their parents to notify them that there were warrants that he had either just filed or was seeking, and that they needed to turn themselves in. And Jeremiah turned himself in with his mother on October 22nd, the following day. In terms of the underlying incident, Jeremiah and his cousin Joshua Witherspoon had arranged for a meeting with the victim, Javion Billings, which they were meeting to do a trade of guns. There is, as I understand it, there is social media which would show, I believe Instagram, which would show that Jeremiah communicated with Javion Billings regarding the scheduling of that meeting. They met up as scheduled. Javion Billings directed them where to park or where to pull their car. Javion Billings went to the car that Joshua Witherspoon, this is his aunt's car, so he was in there in the driver's seat. My client, it was in the front passenger seat, and then there is a third unknown older male who was in the back seat. According to Mr.
Wallach, let me pause you because I don't want to forget. how is it that the guy in the back seat is unknown? I just let you know, I always get leery when, unknown to you, no doubt, but is it the case that your client has no idea why there was a strange man in the back of the car for a gun deal?
No, unknown to law enforcement, and as I'm relaying what information that has been relayed to Detective McClure and by the state at the earlier bond hearing.
Okay.
So that male was not known or is not known to law enforcement, and Mr. Billings, the victim, had other people who were there with him, who were later interviewed by Detective McClure and law enforcement.
Okay.
According to the people who were with the victim, Mr. Billings, when Mr. Billings gave his gun to the car that Jeremiah was in, the person in the unknown person, the person in the back seat, told Billings to then get out of there. That person had a gun which he pulled out. That person ultimately then fired one shot into Mr. Billings' car, killing Mr. Billings. That was based on the interviews of the people who were there present with Mr. Billings. So according to them, undisputably, the person who had the gun and shot Mr. Billings is not Jeremiah nor Joshua Witherspoon, but this third person. That version at least has a little bit of a gap in it because there is Joshua Witherspoon's car, which is shot up with bullet holes, which the police have viewed and have taken in as evidence. But as I indicated, it's undisputed, according to the people who were with Mr. Billings, that Jeremiah did not have a gun, did not fire a gun, and that the other person is the shooter in this. Mr. Jeremiah has been at the Metro YDC since he was turned himself in on October 22nd. His counselor there, Sarah Rosenbaum, has reported that he has been a model of behavior, very cooperative and compliant. There are a number of people who, as the court has helped get those people in and out of the waiting room in the hearing, who are present here. I'm going to introduce those people for your honor. In addition to his family, his mother, Patrice, his father, Prosper, and his sisters, I believe his grandmother, Georgia Johnson, and possibly his grandfather are on the call. Sean Walton, who is a longtime coach, has coached Jeremiah since he was about 4 or 5 years old, is on the call. Ben Hammond, also a coach, who has coached Jeremiah since he was around 5 years old, is on this call. Veronica Dallas, who was a neighbor of the Johnsons, is on this call. She is someone who Jeremiah would do yard work and help with, and she actually found him to be so helpful and respectable that she would take him to her mother's house to have him do work there as well. Each of those and the family members are on the video, Judge. They were available on a previous date when Jeremiah Johnson was going to have a bond hearing. They have been here this morning. They are available if the court has any questions or would like any of them to address, your honor. In light of that, Jeremiah was cooperative, initially reported this to the police, went down, gave a statement voluntarily, was able to be contacted thereafter, turned himself in immediately when he was notified to. I would ask that the court set bond, that he meets all of the Iola bond factors.
Mr. Wallach, couple questions. One, did Mr. Johnson's statement to the detective include an admission that someone inside the car in which he was sitting shot at the Billings car or at Mr. Billings?
Judge, I haven't been given a copy the content of it or answer your question.
Okay, so you don't have that information yet. You just know that your client spoke to law enforcement.
That's correct, Judge. I have not been given a copy of either his statement or just even a Detective McClure's report summarized. his statement. I don't have any.
Okay. Second question. You have made a strong case for Mr. Johnson to get a bond of some sort with some pretty strict conditions, I suspect. But you haven't given me a bond amount. And it would be helpful to get a sense of what would be reasonable from your understanding of the collective family's resources, because with these serious charges, the bond amount is usually a large number. But if a large number is completely inaccessible to the family, then I might as well say no bond. I may say no bond. I haven't heard from the state at all. I haven't heard from the victim's family. But if the answer is not no bond, it's helpful to get a sense of what is in reach and what is not in reach, if there's real estate in the mix, et cetera.
Because I think that the family's resources are fairly limited, especially in light of the pandemic. I've also spoken with Ms. Singleton, who's on this call, and understand that if there is a bond given, that there will be some strict conditions and supervision and follow-up, and understandably so. And I think it's appropriate in this case. And I think Jeremiah's behavior and conduct, both in terms of what happened immediately after the incident and since he's been at Metro, are indicative that he will comply with any and all conditions. In terms of a dollar amount, I'd ask the court to set a bond at $50,000. I'd ask the court to consider a signature bond in light of the conditions and the restrictions that'll be placed on him. But if the court's going to set a monetary amount, I'd ask that it be $50,000.
Okay, thank you. Mr. Pinion.
Thank you, Your Honor. I spoke to the lead detective today, and I think I could answer a few of the questions that you rose with the defense attorney. The defendant and his cousin did come in to report that the vehicle they were in had been shot up, but they did not tell the police the truth about where that occurred and that this was a gun transaction or anything like that. And they did not name this unknown individual in the back seat who is the gunman. It is true, we do have Instagram communication between the deceased, Mr. Billingsley, and this defendant the day of the gun transaction, that they were going to exchange guns the day that Mr. Billingsley was killed.
Let me make sure I'm following that last point, Mr. Pinion. You're saying that the Instagram communications that you've seen are not between Witherspoon and Billingsley or Billings, not between Mystery Man from the back seat, but they're actually between Mr. Johnson and Mr. Billings.
Yes, I got that from the police officer, and that's what his report said. But during the break, I called him to verify that.
Okay.
Yeah, the transaction was between Mr. Johnson and Mr. Billingsley. I did question as well, how did Mr. Johnson and his cousin's vehicle get shot up? And he did say that there were multiple people in the car with Mr. Billingsley, that one of them, a female in the car, did admit that they weren't robbed of all of their guns, that what happened was Mr. Johnson, his cousin, and this unknown person robbed them of the guns that were supposed to be part of the gun transaction. And the statement of the individuals in the car was then as Mr. Johnson and his cousin were driving away, the unknown individual in the back seat fired a shot that hit Mr. Billingsley in the head and killed him. One person in the victim's car did admit that there was return fire. And I heard from the officer that Mr. Johnson's, the vehicle he was in was shot up extensively. So, of course, the officer is not happy that Mr. Johnson nor his cousin have given up who the person in the back seat is. He also told me that he did talk to the school resource officer at Mr. Johnson's school, and I will be forthright with the court. That person was surprised that Mr. Jeremiah Johnson was involved in something that led to a murder. But then when given that he was with his cousin, the resource officer also knew the cousin, and he went, "Oh, okay, well that explains it." And I did look in the co-defendant, who's his cousin, does have a criminal record. So I believe they must have gone to the same high school at one time. So I think that's a more complete story. But the state's contention, based on what we know, is that Mr. Jeremiah Johnson helped set up an armed robbery that led to Mr. Billingsley being deceased. And I do not contest that Mr. Johnson was not the gunman. I have not been able to have contact with the victim's mother. I don't know if she's on this call to express any feelings. I have not found any record for Mr. Johnson that's consistent with what the school resource officer conveyed to the police officer. So that I would ask, if you are going to set a bond, Your Honor, that it would be with the ankle monitor, certainly no contact with the co-defendant, and that it be such a bond that with conditions that would have a curfew, and I would ask for home confinement. And although I can't agree to any amount, that it would be a sufficient amount that would ensure that he come to court, Your Honor. And that's all I have.
Do we have any victim impact information? I know, Mr. Pinion, you said you recently have not been in contact with Mr. Billings' mother. Mr. Summerall, anything from you?
Miss Wanda Billings, I've actually been in touch with her just 2 minutes ago, Your Honor. I've been trying to reach her this morning. She is apparently trying to get onto the Zoom hearing right now in order to have the chance to speak to the court.
Okay, well, if she makes it, I will gladly hear from her. Did she relay anything to you?
Not to me directly. She did say that I did confirm that she wishes to speak. She has spoken to another one of our advocates, Advocate Dilma Dos Rios, where she expressed that she is opposed to bond, Your Honor.
Okay.
Let me see. Let me ask if she's in the waiting room.
She wouldn't go. She comes straight in. Unfortunately, folks don't go to the waiting room. I have to put them there.
Oh, okay.
So she'll land here if she's able to make it.
Okay, let me see if she's in the process of joining us, Your Honor.
Mr. Wallach, I don't know how much you've been able to discuss things with your client. I'm interested in understanding why he is not sharing the identity of the person in the back of the car. It sounds like that's the person he would describe as the one who did the shooting. And those actions are what have made life particularly difficult for Mr. Johnson right now.
Judge, I completely understand that. And the answer, as you will understand based on your experience, is that we're sort of in this limbo because I don't have anybody on the other side who is in a position to speak with me to have those conversations in advancing the case. And
I get it, but it's not foreclosed that Mr. Johnson would want to be more forthcoming about what happened.
It is certainly not foreclosed, and it was something that I attempted and to advance, but for a number of reasons that it just doesn't seem like it can be done right now. And with the timing of the year and the timing of transition, it seems like it may be a bit before that that can happen.
I think that's a fair point. Ms. Singleton, couple questions. First, good morning, and thank you for being here. Do you have any information about a juvenile history for Mr. Johnson? Question one. And then two, if you could explain for the record what conditions you would be able to have put in place for Mr. Johnson if he were granted a bond.
Yes, Your Honor. The defendant does not have any juvenile history.
All right.
As to your first question, if I could just add a few things before I answer your second question.
Please.
I have spoken with Mr. Johnson and with his mother to discuss the type of supervision he would receive if he were granted a bond and a little bit of background information. The defendant was in the gifted program through his early years in school, and currently as a high school student was in AP classes and in the 11th grade. As his lawyer stated, he was the student of the month for the month of November. They actually did not have a student of the month for December, so we're not sure what that situation would have been. He did make the AB honor roll while he's been in Metro, and I do also have a copy of his report card. And Your Honor, I'll just list the classes. He had multicultural lit, he had an 85, algebra 2, an 84. These are final grades, Your Honor. PE, 96, physical science, 80, sociology, 91, world history, 90. So he has managed to continue having good grades. I had also spoken with someone at McNair High School and received basically the same information as Mr. Pinion. They were surprised that he was in custody in custody period, and also for the type of charge. His behavior is good at school. He's not a problem. They have no issues there, as well as he has had no issues at Metro. I also, and as to supervision, if the court granted a bond, his mother works 2 to 10 p.m. for the city of Atlanta, and his father owns a tree service that he schedules his own hours. So they would split a shift to make sure that he had constant supervision, is what has been explained to me from one of them, at all times, 7 days a week. If the court were to grant a bond, I would request that he receive the ankle monitor paid for by the Department of Juvenile Justice that he would wear until the case is over. 24-hour curfew, except for school. School is still virtual at this point. At some point in time, the question would come up as to whether or not he'd be allowed to attend school in person. I have some people that stay at home, have always stayed at home once they receive these type of charges, and others that go to school. So I'll leave that to the discretion of the court. Because he is such a good student, if the court would take that into consideration, it may be beneficial for him to attend classes, but he should be able to continue on online as well. That he have the counselor through the wraparound services that will visit with him at home, that'll be paid for by DJJ, and that he have no social media of any kind based on the information that's been provided about the case. Of course, no contact with his cousin, that's the co-defendant, still in custody. And I believe that's it, Your Honor. Supervision by myself.
Okay, thank you. I see that Ms. Billings has joined us. Ms. Billings, good morning. I'm Judge McBurney. I am involved with your son's case, meaning the case in which your son is the victim, only for purposes of bond, which is what we've been discussing. I'm glad you were able to join us. Mr. Summerall told me that you had some things you wanted to share, and now would be a great time if there are things you want to share. Mr. Summerall can speak on your behalf, or you're welcome to speak for yourself. You're on, there we go.
How you doing? I would like to speak.
Okay, share with me what you will.
Mr. Jeremiah, I don't know him, but my son knew him. I don't care what my son did out there. My son was a good person, and he didn't deserve to get shot. And Mr. Jeremiah, my son knowing him, he was the one that sided up. So I understand him being a good student and all this. That don't have nothing to do with nobody shooting nobody at all. And I got to deal with this for the rest of my life, and my son's kids have to deal with it. I don't even understand. I'm just asking you. Please don't let him go. Like I said, my son, he didn't deserve it. He didn't at all.
Ms. Billings, I hear you 100%. He did not deserve it. There's no justification for what happened. And if Mr. Johnson was involved in this, there's going to be a pretty steep price for him to pay. From what I've heard, and you were not able to join us initially, the state is not contending at this point that Mr. Johnson is the one who shot your son, but that doesn't mean he's not responsible for bringing this all together. And as a result, your son is dead. So that loss is there, and that loss is permanent. Do you have any reason to have a concern for your safety or your family's safety? Has Mr. Johnson or any member of his family tried to reach out to you in any way to harass you or anything like that?
No, but it's like what happened, it happened around the corner from where I stayed. And when that happened to my son, I felt for me and my kid's life, and I left my house.
So you've relocated?
Yes, I done been gone I left my house ever since my son got shot. The next day, me and my other kids left.
Okay. If Mr. Johnson were given a bond with the ankle monitor and the house arrest, et cetera, he'd be living in Stockbridge. I don't want you to tell me where you are now. Keep that under wraps, but are you anywhere near Stockbridge, or is that getting him away from where you are now staying?
No, I'm not near Stockbridge.
Okay, that's good. Are there other things you want to share, ma'am?
No, that's it, because it seems like he's finna go home, but that's it.
Okay, well, I don't know what he's fixing to do, but it's very helpful to hear from you, and I appreciate you making the effort to connect. This is a real tough time of year to be dealing with the kind of loss that you're dealing with, and I hope that you've got family around you and you can help each other work through the grief that you are no doubt feeling because of what happened this October. Please stay in touch with the district attorney's office. They'll let you know what's happening with the case, okay?
Okay, thank you.
Thank you. Mr. Wallach, anything you want to say in summary?
No, Judge. I don't need to add anything more. As I said earlier, I think all that Jeremiah satisfies all the Ayala grounds that he has demonstrated that he would be compliant if released on bond. I think that the number of people who are present for him and have spoken on his behalf speaks volumes, and I know that Your Honor appreciates that. Having done this and been in court for as many years as you have, in as many capacities as you have.
Mr. Johnson, I'll tell you the part that I just don't get is how someone with your potential and the family support you have, I get young men here and there's no dad in the picture, and mom is kind of in and out of shelters, and older brothers in jail, and look at all these people who are here on your behalf. And you got coaches, you got relatives, you got people who stand behind you, and you somehow thought it was a good idea to be in the middle of this thing. And now isn't the time for you to say, well, I didn't know it was going to be a robbery, but the guy in the back seat, X and Y. You're going to talk to Mr. Wallach about that. That doesn't even matter. You got yourself in the middle of this, and it's just sad. First of all, it's sad we've lost Mr. Billings. There was no reason for him to get shot. But it's sad that you have messed up as much as you've messed up. I'm going to set a bond. I hope your family can post it. But what you don't get back is that clean situation. You're not going to walk away from this. There's just not a way that this is going to be, you know what, the state dismisses charges. There's going to be a really messy consequence for you because you were in this mix. And it sounds like you set up a gun deal. This is a junior in high school in AP classes who sets up a gun deal I don't know what AP class you were taking that made you think that that was a good idea. Your parents and your brothers and your sisters ought to be so mad at you. And the fact that you're rolling with your cousin and mystery man in the back seat to do something like this. Nothing good comes out of that. So I'm disappointed. I don't even know you, and I'm disappointed because sadly, I don't know a lot of young men in your situation who are able to take AP classes and have this level of support. And you flush that down the toilet. I hope being at the RYDC has been an eye opener for you, because I'll tell you, going to where your cousin is it's the big leagues. If you mess up while you're on your bond and you reach 17, that's where you're going to go. So you need to take this a whole lot more seriously than you were taking it in October when you were rolling around with your brother in Mystery Man. You have some deep thinking to do as well. The right thing to do is to come clean about what happened. And you and Mr. Wallach are going to have some long conversations about that. But that is the best way to help yourself and the people you care about. So you'll cross that bridge when you get to it. I do believe that there is a set of conditions that I can impose that will, number one, guarantee Ms. Billings' safety and her family's safety, because you're going to stay away from them. But number two, it'll guarantee that you show up for court when you next have court. And you're going to have court. Your case will get indicted, and you're going to need to deal with a murder indictment. It doesn't get more serious than that. And you're a 16-year-old promising sports star and real good student. I mean, you have multi-talented, all thrown away because of this gun deal. I'm going to set a bond that is $50,000 for count one, $15,000 for count two, and $10,000 for count three. That's a $75,000 bond. It's going to be a good bond. I learned, unfortunately, Mr. Wallach, that the sheriff's 10% program ends at the end of the year. There will be no more sheriff's 10% program. There may have been legislation passed that does away with it, but we have an incoming administration that doesn't want to be in the bond business, because that's not what sheriffs ought to do. So it's going to need to be a good bond. It will be subject to the conditions that Ms. Singleton described. You will be wearing an ankle monitor. The good news for you, Mr. Johnson, is your family does not have to pay for it. You will be on house arrest except for school, but you will be in school remotely initially, and you will need to petition me. In other words, Mr. Wallach will need to reach out to me to modify the bond if you're able to go to school in person. Right now, that's moot because all school is remote. You'll be subject, or you'll benefit from, all the wraparound services Ms. Singleton described. So a counselor will come see you, et cetera. You'll need to stay off social media. So that Instagram account you like so much and that you used to set up this gun deal, you're off it. You have no contact whatsoever with Mr. Witherspoon, and whoever the mystery guy is in the back seat, you better not have contact with him. If you get smart and share with your lawyer who that was, if there's any evidence that you've been in touch with that person, that's the kind of thing that lands you back at the YDC. No contact with Ms. Billings' family either. No direct contact. I don't think you'd reach out to them, but your family needs to leave them alone as well. Don't reach out to say, I'm sorry for what happened. Don't reach out to say, why are you pursuing this case? If there's any evidence that anyone on your behalf, Mr. Johnson, was reaching out to Ms. Billings or her family, or to Mr. Witherspoon, or when we learn, if we do, who the mystery man in the backseat of the car was, that's going to wind you back up at the YDC, which is not what you need. We cannot salvage Mr. Billings' situation. He's dead as a result of your gun deal. But there may be some light at the end of the tunnel for you. You're smart and you've been doing well, and folks continue to have faith in you. You need to earn that faith back after you got mixed up with this, but they're standing by your side. Don't disappoint them by messing up with these bond conditions. Ms. Singleton, were there any other conditions that I need to pronounce so that Mr. Johnson hears them, or you and your colleagues will be making clear to him what the lay of the land is?
Your Honor, I just sent you a chat, but I am also in communication with my deputy director. The information that you provided about bonds is new to me.
Oh.
And I'm trying to see if they've made some other provision that has not been presented to us. And I'm waiting to hear back from Ms. Pat, Felicia Pat. But
Good point.
as it stands to this point, we do not handle that.
Okay, well, here's what we're gonna do, because we have 5 other defendants who need to be heard. The dollar amount is the dollar amount. It will need to be something that Ms. Singleton and her team supervise. We're gonna take offline this discussion about how it could be structured. There is currently a Sheriff's 10% program, and I'm happy to say that's how the bond is structured. If Mr. Johnson's family is not able to meet that financial obligation before the year is out, I don't know what would become of that bond order. So that's a conversation Mr. Wallach could engage in as well. But I have outlined what a bond would look like that I would sign, and we may need to get creative with how it is secured. But I don't think we can solve that right now. Ms. Singleton's going to need to hear back from Ms. Pack. Mr. Wallach may need to do some inquiries as well. Mr. Johnson, do you have any questions about anything that I described?
No, Your Honor.
Okay. Mr. Wallach, any questions?
No, Your Honor. I'll communicate with your office and with Ms. Singleton in terms of the 10% and how to secure that bond.
Okay, I'm available anytime between now and the end of the year to electronically sign a bond order. So we're not running into the issue of, well, wait, now it's winter holidays and it won't be till January. If we can figure out how to structure this, we can make it happen. But we just need to understand, what does this transition come January mean to how we might do it, okay?
Yes, Your Honor.
Thank you, Your Honor.
All right, if you're on the call for Mr. Johnson, thank you for being here. If you're on the call for Mr. Billings, thank you for being here. I'm gonna ask you to sign off so we can clear the airwaves for the next matter that we have, which I believe is going to be Mr. Ingram. I need to take a 3-minute break. I bet our court reporter needs a 3-minute break, but let's make sure we are lining up Mr. Ingram next. Are you Mr. Ingram? Great. We need about 3 minutes. Who is representing Mr. Ingram?
Hi, Your Honor. I'm filling in for Miss Megan Eustace.
Fantastic. Your lawyer is right here, Mr. Ingram, and we will get going in just a minute. Thank you.
Hey, Lauren. Lauren, this is Deidre. What's he doing about the Jamie Love? I didn't want him to forget that starts at 11.
So we started already, technically, on the WebEx.
Okay.
It's 11, right?
Right.
Yeah,
So I guess I can't be 2 places at the same time. So I need to, neither can he. So I just need to know what we're doing on Jamie Lee. So you've gone on.
Yeah,
Jamie
it's a plea. Yeah, it's a plea.
Okay.
6 to serve 2. But that's the recommendation, that's negotiation. 6 to serve 2 concurrent with his probation revocation. And he's already in DOC, so.
Okay.
Yeah.
Is that 6 to 2 on both cases?
Yeah.
Okay. Okay, well, he'll let me know then. I just was trying to make sure because I'm gonna have to.
Both cases, that's the revocation and open case.
I think he had cargo theft 2 counts, correct?
Cargo theft 2 counts, yeah. Yeah.
Okay, I just wanted to make sure that I'm not going crazy. Okay, I'll let you go. All right,
Okay.
thank you.
Oh, I'm not sure. I think you're almost complete. Vending machine. Hungry.
I think I am too now, just sitting all morning. Been since 8:30. I walked in at like 8:20. You know, I just, I don't know what's going on. Well, that's what's wrong.
On the chair in her room.
So it's like a year.
Oh, she must have just gotten up.
Really? Weird.
What's going on here?
So I walked in there first. I don't think I have anything, but I'm like, so I just things. So they never called me.
Since my period day is Thursday.
Oh, yeah.
I get like a 2-week break there. At least. Did you get your piece of things?
What case?
Non-complex spaces for the 4, complex spaces for the 6. And then by 12.
It's gonna be up to him. He's gonna address you when he's ready.
I cannot get excited.
Oh.
It's going to be concerned. You gotta wait.
I can't get excited about that. I'm getting annoyed.
Yeah. Oh, yesterday, right? Yeah, I saw you did. She understands it how complex it is. You on all the time. I don't think I'm. What? I didn't get to I think everyone else on there is earlier. I set my 5 deadline. Because my people have been in longer.
So, aggravated,
Everything is aggravated.
Yeah, everything's aggravated. Yeah.
Hello?
Hello, sir. Are you here for a hearing?
Yes, I am.
What hearing are you here for?
Brandon Way.
We haven't reached that hearing yet, sir. So you'll be
Okay, good.
put into into the waiting room probably for a little bit.
Okay.
And as soon as that hearing comes up, you'll be brought back in here.
Okay, all right, good. I had to break away for a while. Okay, so I just wait, right? Okay,
And you said it was for Way that you were here?
yes.
Okay, yes. So number 7. Okay, we'll make sure to bring you back in. Okay.
Okay, thank you.
That's all right.
She's in the main jail, but just let her know that she's ready. So you should be fair.
You have a number of them.
No, I just sent her email. She's really responsive via email.
Okay. Hello. Watch the video because we never got to the case that I'm covering. It's going to be next when the judge comes on the beach. It'll be next. Unfortunately, you are second to the last. Okay, you're number 7 on the decision.
I appreciate it. I just let Ms. McCall know also.
Hey, Lauren, can you hear me?
It's not on. Weird.
The last time she made it, she like go on meetings. We had her picture in the wrong corner. There was nothing going on with that, so she thought it was like.
All right. I know. And I told Deidre we're going to do that at noon. She's going to reach out to DOC to say noon because they were calling. Ms. Johnson, how are you? I'm okay. I don't want to get into a lot of stuff in this large group setting, but it's hard for us to meet one-on-one. You earn too much. You're not going to feel rich. I don't feel rich either as a public servant, but to qualify for what you're trying to qualify for, it's folks who earn about half of what you earn. And I appreciate you have expenses as well, same. But the luxury of having those expenses that are a lot like mine is another indicator that this is one that you're going to need to find the right way to allocate, save, so that you can, you ought to pursue what you want to pursue. But I'm tasked, whoever's presiding is tasked with making sure, because there's a limited budget to support what you're trying to do, that it's for folks who truly couldn't afford it. And they don't have the luxury of, as I said, some of your expenses and expense categories, and certainly not the income that you enjoy, which is not me telling you that you or I and Bill Gates or Jeff Bezos, we're not, but it's not something that the program is designed for. So I feel like Scrooge. I'm not. I'm a nice guy, but I didn't want you to wait a whole lot longer. So you understand. But I hope you're able to take care of what you want to take care of relatively soon. Okay. Have a safe holiday. I'm gonna get to you in a second. I got to do one more bond hearing, and then we'll do yours. How do you pronounce your last name? Okay. If I call you Ms. Yahaya, is that okay? Thank you. All right. Crazy morning. Let us turn to Mr. Ingram. Mr. Adams, I'm gonna put you back in the waiting room, okay? When we get to your case, I'll get you out of the waiting room. All right, let's go on the record. Mr. Ingram, you can hear me?
Yeah.
Okay, if we need to hear from you, you're gonna need to get closer to the microphone. You don't have to right now if you're not saying anything, but we're not gonna be able to hear you unless you're a little closer. I think most of the talking will come from your lawyer and from the prosecutor, but if there's something that we need you to share with us, I'll ask the detention officer to let you get a little closer to the microphone. But can you just raise your hand to confirm you can hear me? Great, that'll do it. All right, why don't we, I want to call the style of the case, and if we can have the entries so that Mr. Forte can make the record. This is position 6, it's 20 CP 195843, and on behalf of the state, we have
Brett Pinion.
All right, and representing Mr. Ingram in a stand-in capacity.
Ray on Bray, Your Honor.
All right, Mr. Pinion and Ms. Bray, thank you both for being here. Mr. Ingram, you are appearing from Rice Street rather than being here in court. I need to make sure you are comfortable waiving your physical presence in court. Are you comfortable proceeding from where you are? Can you raise your hand if you are? Great, you raised your hand. And Ms. Bray would typically be sitting next to you in normal times, but as you know, these are not normal times. Ms. Bray is here in court with me, not sitting by your side. Are you comfortable, Mr. Ingram, having Ms. Bray represent you effectively remotely? She's here, but you're not. Are you all right with that? If you're all right, would you raise your hand? And again, Mr. Ingram raised his hand. All right, Ms. Bray, thank you. You've been very patient. We are moving as safely and quickly as we can.
Yes, Your Honor. As I stated earlier, I'm standing in for Ms. Megan Eustace, who is assigned to represent Mr. Ingram. Your Honor, you have before you Mr. Jacob Christian Ingram. When he came in, he was 25. On Sunday, he had a birthday, so he is now 26 years old.
Happy belated birthday, Mr. Ingram.
He was born and raised in Atlanta, has lived here in Atlanta all of his life. He has 3 children, an 8-year-old and 2 3-year-olds. He graduated high school and did a year of college. He is not working. He receives disability for a medical issue. He has been in custody, continual custody, since December 2nd on this matter. My office has pulled video from the incident location because there's mention made in the police report that describes clothing. From what we could see from the video pulled, we could not see the face of the 2 people. All right.
Meaning the alleged, well, someone's dead, the victim and the assailant?
See the victim's face, of course, but the assailant's face, you cannot see their face clearly on the video from the incident location.
Okay, but you said 2 people. Are there 2 assailants?
There are 2
Okay,
assailants.
got it.
Mr. Ingram's co-defendant is Mr. Jamon Johnson.
Okay.
He was arrested December 16th. So he came in at a later date. Unfortunately, the clerk's office probably has not connected the CP numbers because they're under different CP numbers.
Okay.
Because they came in at different times. But back to the video. So the police have the video from the incident location describing the clothing, mainly. Mr. Ingram was the victim of a shooting a month prior at another location that's a few blocks away. They pulled, from my understanding of what I've read in the police report, they pulled the video from his shooting where he was the victim. He was shot in the arm 2 times, he was wearing a sling, to see, well, they see clothing that Mr. Ingram and Mr. Johnson are wearing. And they're basically saying, this is why they know, or how they know that it is the set, that they are the
Okay, so to simplify it, not this case, but there's video of Mr. Ingram when he got shot and he's wearing a Falcons jacket. And lo and behold, in the video of the victim in this case that we're talking about being shot, there's a guy with a Falcons jacket. Falcons here, Falcons there. It must be Mr. Ingram.
Correct.
Okay.
Although the clothing is just more plainer than that. Black skinny pants, a black jacket, a white t-shirt, Nike shoes.
Okay. Could be anyone.
Yes. Green hoodie, black pocket, black jeans again, and Nike shoes.
Is your client the black skinny pants and black jacket or the gray hoodie, allegedly?
Allegedly, I'm not sure which one it is supposed to be.
Okay.
Because my client was not there. We are pursuing the alibi stance. We have made contact with the alibi witness that we were provided. There's a discrepancy of maybe an hour in the time. That's it. Now, we have not been able to pull video that we may be able to get from the VIC unit or anywhere else during his mode of travel from leaving this person that he was actually visiting. So we just don't have it yet. We were able, though, to get the video from the two different locations.
Any sense that the person who was shot in this case was connected to the situation in which your client was shot?
According to the police report, the decedent's family informed the police that they thought that it was a retaliation for when Mr. Ingram was shot
Okay.
a month earlier. So is that an indication that this person who's deceased may have been the shooter of Mr. Ingram and shooting at Mr. Johnson?
But what you understand it to be is that the decedent's family believes that. It's not that there's already there was an arrest warrant for John Smith, the decedent, for having shot Mr. Ingram, and lo and behold, now John Smith's been shot and killed, and someone who looks a whole lot like Mr. Ingram was on video involved with the shooting. Okay.
So it comes from the decedent's family telling the police that, hey, this is definitely a retaliation matter. So I did not give Mr. Ingram's address on the record because if the family's feeling that this is retaliation, they may want to retaliate back. But I do have the address where Mr. Ingram would be living, and I would be happy to provide that to the court, but off this video thing. So
Sure.
Hearing where it would be, but the court would have that information.
Right. And presumably the state would get to know where it is as well. We just wouldn't
Be able to share that with the student's family or anyone.
So Mr. Ingram is an Atlanta native, all sorts of connections here. 3 kids, not working, disabled. Anything else you want to add?
That he is not a flight risk, he does not possess a passport, he's never been out of the country.
Okay.
He will be here, John.
Got it.
There's no danger of his fleeing or running from the jurisdiction.
Thank you. Mr. Pinion?
Thank you, Your Honor. The state opposes bond, and part of the facts that the defense attorney raised, I have been told a different version. Part of it was what my understanding is that there was an earlier shooting. It was the month before, October 26th of this year. The defendant was shot at a corner store just a couple blocks away, as was stated. The day of the murder, on November 25th of 2020, at the murder scene, the victim on the video was seen coming out of the store, and there are 2 people laying in wait, and they are attempting to hide their faces. They're staying back some, and as the victim comes out, he's basically assassinated. He is shot multiple times by 2 individuals. The officer—
Let me pause you for a minute, meaning the video you've seen or the evidence you've reviewed is that there were not just 2 assailants, there were two shooters?
Yes.
Okay.
The two shooters working together specifically targeted the deceased and were waiting for him to come out of the store. And
No, I got that, but it wasn't just that the shooter had an accomplice. Both of the assailants shot at the victim.
yes.
Okay.
And then fled the scene. As stated, the family of the deceased did feel this was retaliation for the shooting of this defendant the month before. This defendant was with his brother at that time, and I think is the co-defendant in this case. But in addition to what the defense counsel just stated, the officer—
Hold on for 1 sec. What's the retaliation piece, though? It sounds like everyone agrees Mr. Ingram got shot in October. What's the last name of the deceased?
Carr.
Mr. Carr. Thank you.
CARR.
Thank you, Ms. Bray. So why is it that people think that Mr. Carr being shot was retaliation? Is there some suggestion that Mr. Carr was involved in shooting Mr. Ingram?
From what I have been told, the family believed that Mr. Ingram and his brother blamed Mr. Carr for him being shot.
Okay, but you don't know what the origin of the dispute was, why people would think that Mr. Carr wanted Mr. Ingram shot, whether Mr. Carr did the shooting or not, why he had it out for Mr. Ingram.
I don't know but I do know that they blamed him for either shooting them or getting someone to do it.
Okay.
All right. So the officer did go back to that corner store 2 blocks away to look at that video. But what has been conveyed to me, I know this is the bond hearing and not the probable cause hearing. And if it was probable cause, I would know for certain. But the officer, while he's there, he also got the video from that corner store because they are known to hang out there, and looked, and he had video of the defendant and his brother at that corner store the day of the homicide as well. And what he actually saw was a clear picture of Mr. Ingram's face and his brother, the co-defendant. And of course, he could see their clothing as well. And he saw them head in the direction of the shooting location, and appearing to, you could actually see where the victim was going to that store, and that the officer was able to then see that these two defendants, including Mr. Ingram, followed the victim to that location of the shooting and laid in wait for him to come out. So although at the scene of the shooting, the face cannot be seen, you can see the clothing, and it does match the clothing that you see at the other store, and you can clearly see that it is Mr. Ingram's face. So we do have video of the defendant's face that day, and basically stalking the Mr. Carr, who is then executed in the parking lot. So that's the only part that was left out. Your Honor, we believe that he is a risk of committing further felonies. He does have numerous arrests. I also didn't mention he has very distinctive hair, him and his brother, and that was shown on the video. His first arrest, it was July 21st, 2010. And
Tell me, I appreciate he's been arrested a bunch, according to you. Any felony convictions for Mr. Ingram that you're aware of?
Let's see. I'm going to go through the convictions: marijuana and criminal trespass, but those were misdemeanors. Gwinnett County, he was indicted for the felony, let's see, theft by receiving, possession of firearm, drugs. And he was given first offender. And I believe he's still on probation for that. But I do know he was convicted of possession of cocaine with the intent to distribute out of Gwinnett County, yes. And then, yes, that was in 2016, and he received 10 years probation. So he is still on probation for that. That probation was violated the next year. He has a failure to appear. We believe he's also at risk of flight. 2017, his failure to appear was on a misdemeanor charge. And then he violated his probation again, is on his GCIC in 2010, failing to follow the terms. And Your Honor, as to where he would stay if he was out of jail or that, I know that in 2019, and I've read the police reports, he was arrested for aggravated assault for threatening to kill his grandmother and his dad. I've read the victim notes, and then his grandmother and dad did not want to prosecute that. So we have not proceeded with that case, but that is where he was living last year. And so we don't believe he has a stable address. He was convicted of cruelty to children in the 3rd degree in Superior Court here in Fulton County. So that was reduced. That would have made that the 3rd degree would make it a misdemeanor. Then his Gwinnett probation was dismissed on that. And then last year's also as well, he was arrested for aggravated assault. I don't know, that was for shooting at his girlfriend. I know his girlfriend does not want to prosecute that as well. So I don't know the status of that one. But he is a convicted felon. He has a history of failure to appears and arrests for gun offenses. And we believe that he's a risk of flight and a risk to commit further felonies. And that's why the state opposes bond.
Okay. Mr. Summerall, do you have any victim family input from the Carr family?
Unfortunately, Your Honor, we have not been successful in reaching the Carr family. The only individual that I have listed here is Miss Shirley Carr, who I believe to be the victim's mother, and we have been unsuccessful in reaching her.
Okay. Thank you for that update. Ms. Bray, is it safe to say that in the brief time you've been involved representing Mr. Ingram, you have not had an opportunity to review the same extent of video evidence that Mr. Pinion has? It sounded like he was describing some video that you had not seen.
But the video he's describing, well, he's describing video of earlier that day, and Mr. Ingram and Mr. Johnson being back at the location where he had previously been shot.
Correct. Okay. Because what I understood. Okay. What I understood Mr. Pinion to say is that that video on the day of this shooting, Mr. Carr's dad, that particular segment, according to Mr. Pinion, Mr. Ingram's face and hair, distinctive, are particularly visible. So one can see, hey, here's the clothing Mr. Ingram has on not 2 weeks ago or when he was shot, but the day of the shooting. And those are the dots that are connected. And they're dots you haven't, or Ms. Eustace hasn't had an opportunity to review. Okay, got it. Tell me, Ms. Bray, if there's anything you want to say as sort of wrap up or summary on behalf of Mr. Ingram.
Well, Your Honor, I understand what the DA just said about Mr. Ingram not returning to live with the grandparents, but we have found another relative, his uncle, and we have that address name we could provide. So he would have a stable residence, he would have a place to stay. I still say that he is not a flight risk, and I am asking Your Honor to set a bond on his behalf.
Okay, thank you. Mr. Pinion, how readily, Ms. Bray, is Ms. Eustace, she's available to work on the case, or is she out of commission for a while? What's her status?
Had a medical appointment she could not cut off.
Okay.
She has to do that.
So and that's good. I didn't mean to pry that much. I just wanted to understand. I'm going to ask Mr. Pinion to make some more information available to the defense team. And it sounds like he should get that to Ms. Eustace, not to you.
Yes.
Okay. That's all I was getting at. Mr. Pinion, how difficult would it be for you to make available to Ms. Eustace this additional video footage that you've been able to watch that you described for me?
Well, I want to say I haven't watched it. This was what was conveyed to me by the indictment team, and but I can get that. Yes, I don't want to say I can get it tomorrow, but
it doesn't need to be tomorrow. You're going to give me a deadline in a minute. What I'd like you to do, and thank you for clarifying, it was a colleague who reviewed it, not you, but someone in your office has reviewed it. You're not relying solely on what Detective X may have said the footage looked like. Is that correct?
that is my understanding. Yes.
Okay. So you tell me when you can make available to Ms. Eustace that additional video from the day of the shooting of Mr. Carr.
I would say,
I know we're at the end of the year. If you want to say the first week of January, that's okay.
okay, that I would say by the end of the first week of January, considering Christmas. Yeah.
8th. That's, I think, the 8th. So by January 8th, Mr. Pinion, you should get to Ms. Eustace, or a colleague of yours should get to Ms. Eustace the additional footage. And then what I'm going to do, I'm not denying bond, I'm not setting bond right now. I want to give Ms. Eustace an opportunity to review that additional footage. And then if she believes that we ought to reconvene because she wants a chance to describe differently what you've described, Mr. Pinion, I want to hear from her on that. I'm on the fence about Mr. Ingram and flight risk. I don't think he's a runaway from Atlanta risk. It doesn't sound like he always comes to court. There are ways we can help enforce that. I'm more concerned about Mr. Ingram staying out of trouble when he's out. And that could be trouble he causes. It could be trouble that is caused to him because of what Ms. Bray has relayed to me. But most of all, I'd like Ms. Eustace to have a chance to look at this footage because it may change a little bit the way in which the defense is characterizing the state's ability to connect Mr. Ingram to the case. What you should let Ms. Eustace know, Ms. Bray, is that she is very welcome to reach out to Ms. Nelson, my litigation manager, in early January to say, we'd like to get Mr. Ingram back on the calendar because it's with me until he's indicted. We don't have to wait for the magic Thursday morning presiding calendar. We would do it at a time that is mutually convenient for Ms. Eustace and Mr. Pinion or whoever is going to be replacing Mr. Pinion in this capacity. And we will pick up where we left off. Does that make sense?
Yeah.
Okay. Mr. Pinion, anything else?
No, Your Honor.
All right, Mr. Ingram, so you understand, I'm not saying no bond. I'm not saying yes bond. I want to make sure your lawyer has a chance to look at a little bit more of this video evidence, okay? And then if we need to get back together, you will have my undivided attention at that time.
We're clear that it's the video from the food mart that they're saying they have of Mr. Ingram and Mr. Johnson prior to the shooting at the other location.
Day of, correct. Yep. Yep. That's and to be clear about how Mr. Pinion caveated that, that's what's been relayed to him. He hasn't seen it, his colleagues did. Of course, if what Ms. Eustace gets is grainy black and white footage from November of 2018, again, we should get back together. And it will be Mr. Pinion or his colleague having to amend what they shared. All right, thank you.
Thank you.
So, Jail, before we turn to Mr. Lucas, who would be next, I have my second and final Department of Corrections WebEx that I need to turn to. And then we'll pick up with Mr. Lucas and keep powering through this presiding bond hearing calendar. Thank you again for everyone's patience. Yes, ma'am.
Brendan Ray is number 7 on your calendar. He hired private attorney Ed Adams, and Mr. Adams is one, so he's present for.
Great. Mr. Adams has been periodically resurfacing. Good to know that. Thank you. That would explain, because I didn't see his name anywhere, and I wanted to tell him, you don't have to keep showing up. So he's in. All right. So Ms. Bray, you are you also Jamila Lee for today?
The first one, I think this is the one you just called. The child molestation.
Okay, I've seen his name on there. So that's Mr. Lewis, is his client. And then Ms. Lee also has Mr. Lucas, which is a murder case.
Okay, but our office filed the conflict.
I heard about this, and Mr. Cho's colleague is a little wrapped around the axle on this one. Because he didn't file a bond motion and didn't know he needed to be ready for a bond motion today for Mr. Lucas. I don't know, Mr. Cho can talk about that, but are you going to handle Mr. Lucas, Mr. Cho?
Yes, sir. Our office filed a conflict and Ms. Lee sent notice to Ms. Nelson that the conflict was filed.
Well, you're with the PD's office, right? So you're not the right person to address. There is a conflict defender who's been assigned to Mr. Lucas. Don't know that he'll be joining us because he learned either late last night or today and was frustrated. He doesn't want to make life difficult for Mr. Lucas, but he also doesn't want to be unprepared. So I suspect we will not do Mr. Lucas. And then we would be, what's up next after that is Mr. Bailey, which is Mr. Cho's. So just know it's Lucas then Bailey, but right now, get on another WebEx. You are done. Happy holidays. Be safe. Thank you for being here. Ms. Yahaya, I have signed your paperwork. You qualify for that. I've signed it, and deputy is going to get you your ID and your other card and your paperwork, and I hope that goes smoothly for you. Have a safe holiday, okay? You too. Mr. Melnick, what brings you to our bond Zoom call?
Judge, we have a motion at noon.
Oh, with Ms. Phillips.
Right.
Is she with you?
She is not.
Okay. Is she headed my way?
Judge, I will be candid with you. I had spoken with her, I think about a week ago or so. I reached out to her again this morning and I have not heard from her.
Okay.
So
well, we'll see what happens. All eyes will be on that. I'm going to disappear for a little bit because I have to do a WebEx, and then I'll be back and we'll figure out what we're going to do. We're a little congested today with these presiding bond hearings. So we'll figure out, we'll wait a little bit for Ms. Phillips. I will not keep you on this call indefinitely. It was calendared for noon? Okay, all right. Okay, so what we'll do when I get off the WebEx, if Ms. Phillips is not here, we'll have a discussion about consequences. If she is here, we'll figure out what we're gonna do, okay? So I'm gonna hand the hosting back to Ms. Nelson.
Well, Judge, I'm gonna be on the call with you. I have to do the web too. So we'll just hold the call open and I'll switch to the web.
Well, I have to get off here. Well, I guess they don't.
Well, I can keep mine on because I'm going to go to my computer. I'm on my iPad, so I should be fine to keep the meeting open.
You're the host. I'm leaving. I'll be back.
Okay.
Okay. Mr. Warren, you're going to give me a minute. I got to do something else, and then I'll take a look at this, okay?
No problem.
Okay, good.
Hello?
Judge will be taking the bench in just a few minutes.
Thank you.
Okay, I am back. Thank you again, everyone, for your patience for this world's longest presiding bond calendar. We're done with all the WebExes in the Department of Corrections. We will not be going back there. We are going to press on with the bond hearing calendar. And the next up was Mr. Lucas. Mr. Melnick, I'm going to give your client 3 more minutes till 12:30. So let's take care of Mr. Lucas, which I think is going to be pretty quick. And then we'll talk about your client situation.
Thank you, Judge.
Mr. Cho, it's Mr. Lucas's case where your office has the conflict. Okay. Mr. Lucas, can you hear me?
Yes, sir, I can.
Hey, I'm Judge McBurney, and I will be handling any questions about bond in your case because it's been assigned to me just for purposes of bond until you are indicted. Assuming you're going to be indicted, I guess the state could always dismiss your case as well. But if you're going to be indicted, until you are, I'm the judge you'll work with on questions of bond. And your initial lawyer, Ms. Lee, filed a motion for bond, which is why you are sitting where you're sitting in front of that screen. Since that time, Ms. Lee and her colleagues have learned that they have a conflict. Mr. Cho, do you happen to know the nature of the conflict? Okay. I don't know what the conflict is. It could be that their office represented the decedent in your case. Do you have a co-defendant, Mr. Lucas?
No, sir. Ms. Lee informed me that one or more of the witnesses in my case have been represented by the Fulton County Public Defender's Office, and so that's why I would receive a conflict attorney.
Excellent. Well, you know more than I do, and I appreciate Ms. Lee contacting you about that, and that's exactly what's going to happen. And in fact, you have been assigned an attorney, but he is so new to the case, he did not want to go forward today, not having spoken with you or knowing anything about the case, because what kind of job would he do? So he's going to connect with you, and we will reset your case. It'll be with me, and we will talk about your bond after. I think the gentleman's last name is Foreman, but don't hold me to that. It's someone from the Conflict Defender's Office. He will get with you, and then he will let Ms. Nelson, who's a colleague of mine, know to put your case back on a calendar so that we can talk about bond in your case. All right?
Yes, Your Honor. I have one thing that I would like to say before we move forward from my case.
Well, let me pause you for 1 second. You don't have a lawyer right now on this call. There's a prosecutor on the call. So you should not say anything substantive about the case, like I wasn't there, or I was there, or it was self-defense, because that can be used against you. and there is not a lawyer representing your interests on this call. Now, if you want to just let me know you're unhappy with your lawyer or you don't like it in jail, I'm happy to hear that. But if it's about your case, you really shouldn't talk about it right now, because folks who do not have your interest in mind are listening, and no one who has your interest in mind, other than me as the neutral judge, are participating, okay?
Yes, sir. It's not pertaining to the case, Your Honor. It's pertaining to a situation here at the jail.
Okay.
I have been informing them for the past about 72 hours that I've been having anxiety attacks and hearing voices. I have been diagnosed with bipolar manic depression and PTSD and personality disorder. I had a lieutenant on the second shift here yesterday by the name of Lieutenant Howard, who he got upset with me. He began to make threats to me, and I told him that I go to court on tomorrow and that I would inform the judge. And his exact words verbatim to me, and excuse me for using expletives, but his exact words to me, Your Honor, was, this is my house, shut the fuck up. The judges don't run shit but the courthouse. And he told me that if I didn't shut the fuck up, he would choke me to sleep. I asked him if I could see a mental health professional. He said that he wasn't going to do shit for me. He said that if I were going to kill myself, I wouldn't tell anybody, I would just do it. He said that he's seen hundreds of suicides here at the jail, and none of them told anybody they were going to do it. They just killed themselves. So he told me to do everyone a favor and shut the fuck up and just kill myself.
Okay, and you said this was a Lieutenant Howard?
Yes, sir. Lieutenant Howard, he works the second shift, and the sergeant's name on that shift is Sergeant Robinson. But they both were very rude. Also, when they removed me from my cell, because when they wouldn't get me any help, I flooded my cell. They had the CERT team come and remove me from my cell. They removed all my personal property. They brought me to the 7th floor to disciplinary lockdown. And when I received my property back, several items that I purchased from the commissary were missing. About $20 worth of items was missing from my property. And, you know, I know for a fact that these things aren't right. The threats that he made to me under Georgia Penal Code is terroristic threats. The theft of my property is considered theft by taking. I really don't think that anyone is above the law. And I believe it's truly unfair for them to be able to say and do the things that they've done to me and just get away with it.
Okay. Well, I hear you, Mr. Lucas, and the events you described are concerning. I wasn't there, so I don't know the whole story. I can let you know that if Lieutenant Howard told you that that thing about the judges, he's mistaken. But I'll obviously need to learn more about it. Mostly, though, I want to make sure that your mental health needs are being addressed because you need to be safe. I don't want you to be a risk to yourself. I don't want you to be a risk to other inmates. I certainly don't want you to be a risk to the detention officers because you might be working through some mental health issues. I think the fact that you brought this up in this setting means that you will get an appointment so that a medical professional can hear you out and decide if there ought to be some medical intervention in this situation. And what you ought to do is let Ms. Lee or your new attorney know ASAP if that has not happened, and then they can let me know, and I will help demonstrate that, in fact, the court's reach is a wee bit longer than what you were told. But for now, you ought to lay low, and we're going to make sure your new lawyer reaches out to you, okay?
Yes, sir. And the housing unit that they have me housed in at this particular time, Your Honor, does not have phones that we can use to contact anyone with. And I do not feel safe here at Fulton County Jail, Your Honor. I really don't. And my last question to you is going to be, if I could be housed at another facility pending my court hearings, or is it possible for me to be loaned out or housed at another facility? Because I do not feel safe here. I truly don't, Your Honor.
So, Mr. Lucas, that's the kind of thing to discuss with Ms. Lee or the new attorney. How was it that Ms. Lee was able to share with you that she had a conflict?
Well, I was able to call her. At that particular time, I was in a housing unit that did, in fact, have phones. But since this incident with the sergeant and the lieutenant, I've been moved to a disciplinary housing unit, which does not provide working phones for us to call anyone. It doesn't have working phones. It does not have television. They said that phones and television is a privilege. So the only way that I'm able to talk to my attorney or anyone is if they call here to the jail. And if it's not my attorney, then I won't be allowed to talk to them. And this is without any charges or hearings or me being found guilty of anything. As a matter of fact, the whole situation with Lieutenant Howard started because I told him that because I have the presumption of innocence until being proven guilty, which means I still maintain my constitutional rights, that I have a right to the freedom of speech without being punished for that unless I make a threat. And that's when he told me to, quote unquote, shut the fuck up.
Okay, well, I think I understand a little bit more about the interaction you had with Lieutenant Howard. We will reach out to your new attorney to let him know that he needs to very promptly contact you to hear more about what you shared with me and also to figure out when we can get you back on for a bond hearing, okay?
Yes, sir.
All right, thank you. I saw that.
Julia, this low message, tell her to come down again. She says that for some reason it's dropping the Wi-Fi signal.
Okay.
It's disconnecting.
So we can have Mr. Cho go to the podium. Yep. Mr. Cho, you're up next if you represent Dwayne Bailey, because Dwayne Bailey should be next. Are you Mr. Bailey?
Yes, sir.
Great. Let's deal with Mr. Melnick. Mr. Melnick, any update from your client?
Sorry, Judge, I didn't unmute myself there. No, unfortunately, I've texted her, I've sent her an email, and I haven't heard anything from her. She and I have been in more or less regular contact with one another, and we had a court date in this case, I think right before or right after the first judicial emergency. And she was there for that. So I understand, the reality of her not appearing today. The only thing is I will just tell everybody that if I do hear from her, I'll probably file a motion to set aside whatever orders entered today.
Sure. And if you get her to appear, either she walks in here, and she probably need to walk in here rather than appear remotely, but let's see what the public health situation is at the time, then we could certainly talk about setting something aside. But what I'll do is ask Ms. McCauley and Ms. Nelson to do whatever needs to be done to get a bench warrant issued for Ms. Phillips, and that's how we'll handle that one.
Okay, thank you, Judge.
Your Honor, she already does have a warrant from pretrial services out, but.
Sorry. She already does have a warrant from pretrial services. I'm fine with having a bench warrant issued as well.
Let's do both.
Okay.
I've had mixed success with the pretrial piece, and a bench warrant tends to make it onto more systems. So let's do both. That would be great. All right, Mr. Melnick, thank you for dialing in. I appreciate it. You have a safe rest of your holiday.
Thank you, Judge. You too.
All right, let's go on the record in Mr. Bailey's case. And Mr. Adams, you are up right after Mr. Bailey. Mr. Way is after Mr. Bailey, so don't go anywhere. This is position 5. It's 20 CP 195731. Mr. Bailey is charged with kidnapping, aggravated assault, and rape. He is represented for this bond hearing by Mr. Cho, and Ms. McCauley from the District Attorney's Office is here for the state. Mr. Bailey, all we're going to talk about today is bond. I'm Judge McBurney, and I am your judge for all matters bond unless and until you are indicted on these charges, okay? I can't hear you.
Yes, sir.
Great, that works for me. I think Mr. Cho will be doing most of the talking, but if we need to hear from you, we'll just make sure you lean into that microphone. All right, Mr. Cho, please.
Thank you, Your Honor. Before you virtually is Mr. Bailey. We believe the correct name is Patrick Bailey, just for the court's knowledge. I have spoken with Mr. Bailey, and we have discussed the virtual format, and I don't believe there are any objections.
Mr. Bailey, Mr. Cho is bringing up something important that I should have brought up with you. You have a right to be in court for this discussion. If you want to exercise that right, I don't know when we can have this bond hearing. It'll be sometime in the new year. You also can waive the right and authorize Mr. Cho to argue on your behalf here in court while you are able to see and hear everything we're doing. Do you waive your right to be here in court?
Yes.
Okay, then we'll proceed today. Back to you, Mr. Cho.
Thank you, Your Honor. Mr. Bailey, Judge, is submitting to the court's authority, of course, and is asking the court's consideration for mercy today. He does have a good address in Stone Mountain, Georgia. Judge, I have the actual street address if the court would like. And he does have extensive ties to the community. His mother-in-law, his brother, both live in Georgia, and the address that I have would be with his mother-in-law. Judge, he's been in Georgia 20 years. He does not own a passport, and he's the father of a 14-year-old and a 6-year-old, excuse me, and they both live in Georgia as well with their mother. So, Judge, he does have ties to the community, and I don't believe that there's any indication that he's a flight risk. Some background for Mr. Bailey, Judge, he does have his GED. And he was working previously prior to his incarceration. He does landscaping work and construction work. He's been doing that his whole life professionally. And Judge, his last job he's been at for 5 years. Judge, he does want the court to know in this case that he does believe that, well, let me strike that. Judge, I will say this. My client has already been swabbed in custody at the jail. He wanted to emphasize to the court that he was cooperative with law enforcement when that occurred. I think ultimately it may be dispositive in the case. And so, Judge, he wanted the court to know that he was cooperative with that. Judge, as far as criminal history is concerned, he, I believe, has one prior felony conviction. We believe that it's a first offender. I will defer to the state or to pretrial or to probation. But it's our understanding, Judge, that it's a burglary from 2008 in Bibb County. There may be a possible hold for him, but the time he has left on balance is about 3 months. So we would estimate he'll be done with that sentence in March of 2021. Judge, emphasize to the court that that burglary is a commercial burglary, and that there were no individuals inside the home, inside the building, and that he has taken responsibility. Besides that felony conviction, besides that first offender, for the felony, Judge, we don't believe there's any felonies on his record. There may be some assorted misdemeanors, including theft by shoplifting, but no major arrests within the last 3 years, Judge. Emphasize to the court as well, as far as Ayala is concerned, that my client does not know Ms. Wimby in any sense of the word prior to this alleged interaction. He does not know where she lives. He has not contacted her. He has no knowledge of her location at this point. And so, Judge, we are emphasizing to the court that he has minimal history, no violent history, nothing domestic, and minimal FTAs and bench warrants and things of that nature. We are asking the court to consider a reasonable bond in this case. My client, while working, has suggested an amount of $17,000. Judge, if the court's not inclined to that number, Judge, we are asking for a reasonable amount, but we do believe he does fit the Ayala factors, and Judge, he just is again, placing himself at the mercy of the court. Thank you, Your Honor.
Did Mr. Bailey explain where 17 came from?
I did not go in depth, but he basically stated 5 each.
Okay.
Ish for the major counts was the amount he thought he could possibly make.
Okay, got it. Thank you. Ms. McCauley.
Your Honor, the state would be opposed to bond in this case, largely based on the defendant's actual criminal history, and not so much any felony or misdemeanor convictions, but there's a pattern of probation violations that indicate that that the defendant does not follow the orders of the court. He does have that conviction, I believe it's out of Bibb County for burglary. Mr. Cho was correct in that statement, but then he has a 2010 probation violation for some charges out of Bartow County, 2012 probation violation out of Bibb County, a 2015 probation violation out of Rockdale County, a 2016 probation violation out of Rockdale County, 2018 probation violation out of Bibb County, and then a 2018 and 2019 probation violations out of Rockdale County. He does have some other convictions that I think are of note for the court. 2015, he was convicted of fleeing and attempting to elude, along with willful obstruction and misdemeanor willful obstruction out of Rockdale County. Indicative that he does not like to follow the law, does not like to follow the orders of probation, would likely not return to court and follow the terms of a bond order should that be issued by the court. As to risk of intimidation of victims and witnesses, Mr. Cho is correct that the parties do not know each other. The facts and circumstances surrounding this incident are relatively violent, so the state does have a concern for Ms. Wimby's safety, although she does not know the defendant, nor has he attempted to contact her from the jail. I have reviewed all of his jail communications, both complete and incomplete. He has not attempted to contact her. And then risk of flight from the jurisdiction. This defendant does not have a history here in Fulton County. He's mostly been located in Bibb and Rockdale County. He has one arrest or two convictions for theft by shoplifting misdemeanor out of DeKalb County, and then another arrest for peeping Tom out of DeKalb County. So he is not a resident of the jurisdiction and does not have ties to the Fulton County area. And then lastly, risk of committing additional felonies pending trial. The defendant's criminal history is indicative of petty theft. Misdemeanor offenses is not indicative of violent felony offenses. However, given the nature of this particular case, the state would argue that there is a potential for additional felonies to happen pending trial. I would also like the court to note this defendant was released from the Department of Corrections on April 17th of 2020, and this incident occurred in November of 2020. So not even a year after he was released from custody has he found himself back in custody again.
Ms. McCauley, Mr. Cho mentioned that there's been some collection of DNA from Mr. Bailey. I assume that hasn't been processed yet, or we'd be talking about a real important piece of evidence.
It has not. It has not. I have reached out to APD to find out if it's been transported to the GBI, and I have not received a response. But once I do get a response and timeline as to when that will happen, I will obviously ask for it to be tested.
Sure. But there's something against which to potentially match it?
Yes, Ms. Wimby did receive a rape kit.
Okay. And how is it that Mr. Bailey is the suspect in the assault on Ms. Wimby? If they're strangers, was there a photo ID?
It's my understanding there was a photo ID.
Okay. All right.
And I learned that from speaking with the detective. I've not read through the police report. It's not been submitted, but I've learned that through speaking with the detective.
Got it. And this is all fairly new, I understand. Okay. Mr. Cho, anything you want to say to wrap things up?
Judge, I think just in conclusion, there is some history. I think most of it stems from the burglary from 2008. I apologize. I was not aware of the fleeing attempting to elude. I'll check on that with the GCIC, of course.
It was a misdemeanor, Mr. Cho.
Oh, thank you. So, Judge, we are asking the court to consider a bond for today, a reasonable one. Thank you.
Okay. Do you have a sense, Ms. McCauley, as to the kind of turnaround the GBI has? Let's pretend they get it just at the end of the year, so it's quiet time. But does it typically take months or weeks, or testing marijuana is one thing, DNA is another.
So the last time I checked, it was 90-day turnaround.
9 or 90?
90,
Okay.
90-day turnaround. I don't know if that has changed in recent months.
Okay. Well, the number one factor that I'm supposed to assess is the likelihood that Mr. Bailey would show up in court. And I don't know that what I've heard today militates against that. Mr. Bailey has been here for 20 years and has some anchors. I appreciate they're not necessarily in Fulton. It sounds like Bibb and Bartow are where Mr. Bailey spends a lot of time because he keeps getting his probation revoked there. Or at least violated. But that's still Georgia. It's not a jurisdiction where it would be harder to get Mr. Bailey in here. That said, these are very serious charges. And while Mr. Bailey has nothing in his record other than peeping Tom that suggests that he has some proclivity to engage in these kinds of crimes that he's been charged with, he has not managed to stay out of the courtroom for very long. It's a remarkable set of probation violations, and they may be for fairly mundane things, but it just keeps happening. So there's tension between Mr. Bailey doesn't seem like he's going to go anywhere, but when he's not going anywhere, he's still getting in trouble. However, what he's getting in trouble for is nothing along the lines of what we see here. So I am going to set a bond. I suspect it's going to be a bond that is difficult for Mr. Bailey to make, but we ought to reconvene as soon as we get results from the GBI if the case has not yet been indicted. In fact, we have to reconvene before then. If it is in fact 90 days to get it done, we may be bumping up against a deadline that, if a bond's already set, I don't know that we're obligated to change things, but we ought to reassess if Mr. Bailey remains in custody and he has not been indicted and he's not able to make the bond. Mr. Cho, you are free to petition for a reconsideration because a bond Mr. Bailey can't make is in many ways no bond. And I'm comfortable saying no bond if that's the right situation. Based on what I've heard here, I don't think it's quite the right situation. The fact that no one's been bothering Ms. Wimby and they're strangers makes me think that it would be pretty easy to keep Mr. Bailey away from Ms. Wimby until the matter's resolved. So what I'm going to do is set a bond of $30,000 as to, when I say count one, I can't find a complaint, but kidnapping is $30,000, rape is $30,000, and aggravated assault is $15,000. So it's a $75,000 good bond. A condition of the bond would obviously be no contact with the victim in this case, direct or indirect. Mr. Bailey would need to maintain employment. He would need to stay at that Stone Mountain address, and you'll need to provide that to Ms. Nelson, Mr. Cho, because I'll want that baked into the bond. That's home for Mr. Bailey, and if he's not found there, then that's a problem. Ms. McCauley, any sense of whether this happened during the day or at night?
I believe this is a nighttime incident.
So, Mr. Bailey, you're going to have a curfew. You will need to be at your mother-in-law's address from 7 p.m. to 7 a.m. You can be out and about during the day if it's for work, but otherwise you need to be at your mother-in-law's place. Mr. Cho, if work is somehow something where that set of hours doesn't work, in other words, that curfew interferes with Mr. Bailey's livelihood, just let Ms. Nelson know and we'll check with Ms. McCauley, and I might be willing to modify the hours. But for now, it would be a 7 p.m. to 7 a.m. curfew. I think that's it for conditions. Any other conditions, Ms. McCauley?
Just to stay away from the victim, Your Honor.
Okay. I think I said that, but if I didn't, no contact, direct or indirect with Ms. Wimby. Mr. Cho, anything else on behalf of Mr. Bailey?
No, sir. As with the court's permission, may I go back to the office to email Ms. Nelson the address?
Sure. I won't sign it till you do that. She won't send it to me till you do that. Mr. Bailey, that number may seem like it's too big. I think it's the right number, given the very little information I have. If you and Mr. Cho learn more about the case that makes it more compelling that I lower the bond amount, Mr. Cho will get us all back together. But that's where it's going to be until there are further developments in the case, or there are no developments. If it's been 6 months or 3 months and nothing has happened, we ought to talk again, because nothing means Mr. Bailey wasn't able to make that bond. And then we ought to talk again to see if I should change it. Okay, thank you.
Thank you, Your Honor. Judge, that concludes my business. May I be excused?
I think so. Let me make sure. Yes, because Mr. Adams and Mr. Hudson are the last two attorneys. Thank you.
Your Honor. Merry Christmas, Happy Holidays.
You too.
About like 5 minutes to get down.
Oh, Ms. Turner, I did not. I'm sorry. Yes, sir?
About 5 minutes, I'll be down at 6 North.
No problem. Ms. Turner, I did not ask you if there was a victim impact statement from Ms. Wimby.
I think it might be.
So I can see you're not on mute, but I can't hear you. Still can't hear you. Maybe we waited so long to ask you questions, your microphone just of old age.
Can you hear me now? Can you hear me?
Yes, that's much better.
Okay, I apologize. I do apologize. We did reach out to Miss Bimby on several occasions, and she has not corresponded back with us.
Okay, well, then I'm glad I forgot, my mistake, but I'm glad there wasn't something that we failed to include. So we're going to sit tight while they get Mr. Way. Mr. Adams, you ready to go when they get Mr. Way on the screen?
We are, Your Honor.
Great. Thanks for your patience. Ms. Nelson, if you need to go, can we get someone to plug in, or how are we managing your situation? Oh, I see Ms. Hansberry.
Yep, she's right on time. She's getting ready to, I was just sending an email to her.
Great.
So we have possessions 3 and 7 left.
Thank you.
Thank you. I'll check in with you guys later. Thanks.
Yep, take care.
Judge, what number are we on now?
We are doing number 7, Mr. Way. That's what I was told, that he would be next.
Is that Mr.
Way.
Adams's case?
It is.
Okay, I'm gonna run upstairs and get some paperwork real quick. I'll be right back. No, the murder's not mine. The last one is.
So we have two more positions. And then. Yes, ma'am. I just turn it up. That's okay. Thank you.
Have a good lunch. Hey, how are you?
All right, how you doing, Judge?
Okay.
Love the new car?
Yeah, it works. At least it's the same everywhere. We had this weird situation going on because of some leaks where we had about 4 different carpet types over there.
For no reason, it makes the courtroom looks a little bigger.
Good. Guess it's only fair that they make us wait for a little while. Oh, we got someone there. Let's see. Hey there, is that Mr. Way? Are you Mr. Way?
Yes, sir.
Great. All right, well, let's get started. Are you ready, Mr. Forte? Okay, this is position 7 on our presiding bond calendar, State versus Brandon Way. It's 20 CP 195884. We've got Mr. Way calling in from the county jail. He's represented by Mr. Adams. Good afternoon, Mr. Adams.
Good afternoon.
And the state is represented by Mr. Pinion for purposes of this bond hearing. Mr. Way, all we're going to talk about today is bond. Mr. Adams has filed a motion to try to get a bond set for you. You're in a no bond status right now. You're charged with murder. Mr. Pinion's going to share with me what the state thinks about bond, and then I'll let you know what I'm going to do. I'm Judge McBurney, and I have your case only for purposes of bond. If you are eventually indicted for this murder, that'll get randomly assigned to one of 15 judges. It could be me, it might not, but I'll definitely be handling your case until it's indicted whenever we need to talk more about bond. Does that make sense to you?
Sir.
Great. Mr. Way, I need you to tell me that you are waiving your presence to be here in court. You have a right to have your bond hearing in court where I'm sitting and you have a right to be here. Are you waiving your presence and willing to proceed from Rice Street?
Yes, sir.
Okay. You also have a right to have Mr. Adams sitting next to you, but obviously he can't be where you are right now. Are you willing to let him dial in remotely?
Yes, sir.
Okay, then we'll do that. Mr. Adams, tell me about your client and why you think he should get a bond.
Yes, Your Honor. My client's 33 years old. He is married, been living with his wife for 6 years. They have 2 kids, one stepchild and a 2-year-old, I believe. They live at 4699 Pine Circle, Ellenwood, Georgia. Prior to this incident, he was employed at Comfort Inn as a supervisor. He can go back to work there, I believe. He is on probation. I let him defer to probation on what that's about. I think he was placed on probation in 2017. This is the murder charge, but I let state do the facts. But what I know, his reason of being charged is he had an argument with one of the victims. Other than that, I know no other connection, and we will be seeking a reasonable bond.
Okay. Mr. Adams, did you say that Mr. Way lives in Ellenwood? I didn't hear the city.
Yeah, I believe it is Ellenwood, yes.
Okay. And he's been working at a Comfort Inn as a supervisor, and you believe that he could go back to that job?
According to him, he's been supervisor, doing a good job, so they're willing to take him back, yes.
Okay. All right, Mr. Pinion, share with me, please, the state's perspective.
Your Honor, the state's perspective is that we oppose the bond. This is a triple homicide, 3 malice murders. There is evidence of a disagreement with one of the murder victims, a longstanding argument about a years ago drug transaction. Mr. Wade thought that he was taken advantage of in that, and that there had been threats by Mr. Wade to kill that victim for some time. There is some video showing that confrontation. That victim told somebody that they were leaving those premises because they were scared. And it does show Mr. Wade coming back, appears to be looking for the intended victim, and then going in the direction of where the victim had left. The intended victim did not live far away. The 3 victims were relatives. They were gunned down with the same gun, and immediately the police knew who the suspect was and started looking for him. They were able to. They could not get him to answer his phone. We believe he's a risk of flight, in that there was a female that would answer the phone for the defendant and say it was his phone, but that he wouldn't come to the phone. Police were looking at his last known address, couldn't find him, and I'm not sure where they were finally able to locate him. We believe he's a risk of further felonies and also of flight based on his record. His conviction started in September 1st, 2004. He was arrested and then convicted for carrying a concealed weapon and a misdemeanor obstruction and possession of a firearm by someone under 18. Then he was again convicted 1 month later in October of 2004, again of possession of firearm by an individual under 18 and obstruction of justice. In 2005, he was indicted for theft by receiving, and he failed to appear on that. And so there was a bond forfeiture.
He has a couple of 2007 arrests. He was indicted in 2007 for cocaine with intent and bonded out, and then he failed to appear on February 6, 2008 on that charge. So there had to be a bench warrant. Skipping on to 2009, he was arrested for aggravated assault and possession of a firearm by a felon, and he failed to appear after making bond, and then was convicted on May 20th of 2010. During that time, he was charged with escape, and that was then dropped when he pled guilty. The arrest continued 2011. He pled NOLO to obstruction again and to battery. And I think this may be what he's on probation now for. 2015, there's an arrest for cocaine with intent, family violence, and obstruction of justice. I don't have a disposition on that on his GCIC. If that's not what he's on probation for, in 2019, I'm showing this as open. He was arrested for obstruction of justice and driving on a suspended license. So we have pleas of guilty, at least 3 of them to obstruction of justice. 3 of them to obstruction of justice. 3 of them to obstruction of justice. 3 of them to obstruction of justice.
That was odd.
Yes. Yes. And he is a convicted felon. In addition to the obstructions of justice, there's 3 failures to appear. So we do believe he's a risk of flight and further felonies, and we would ask that bond be denied.
In terms of felony convictions, there's the aggravated assault and possession of a firearm by a felon. What other, you focused on arrests, and it wasn't always clear to me what turned into a felony conviction. I guess the 2015 was a possession of cocaine.
Yes, but I don't know if he was convicted or not. His GCIC just does not have a disposition on a number of these.
Okay.
I do see 2007, the cocaine with intent that I mentioned, he was convicted.
Are these all Fulton County cases?
Most of them are. Most of his convictions all of his convictions for obstruction are Fulton, and those are all misdemeanors, of course. I believe they are, let's see, I've got it back up now. And it does appear that they are Fulton, every one of them, as I go back in time.
When did the triple homicide occur?
I'm going to have to, one second, I had trouble getting it, and I did get the police report this morning, and I have found it.
Can I help, Mr. Finn?
You could, if it looks like it was October.
October 5.
Yeah, okay. I couldn't read the 5. October 5th, 2020, Your Honor.
And Mr. Way was not arrested until December.
That sounds consistent. I don't know the specific day. I do see a lengthy period of time where the police were looking for him, going to his last known address, making phone calls, and then we're following leads towards Tifton, Georgia.
Okay. Mr. Way, how long have you lived at this address at Pine Circle in Ellenwood?
I recently moved from 178 Murray Avenue. That's where my children live. And I've been with her for 6 years. I never ran. I never left the state.
Okay, I don't, right now, you shouldn't talk a whole lot about the circumstances of the case. I just wanted to know this address that Mr. Adams shared with me, Pine Circle in Ellenwood. Is that not the right address?
Yes, 4699 Pine Circle.
How long have you lived there?
I had just recently moved from 178 Murray Avenue. We've been there for like 4 or 5 months.
Okay. Mr. Pinion, anything beyond your understanding that in theory, in the distant past, one of the deceased had an argument with Mr. Way that connects him to this case?
Well, yes, that this has been going on for years, and that individuals notice a very loud argument between the two of them shortly before the murder, where the defendant was threatening the victim and left to go get something. And there is video. He comes back wearing a long jacket that he did not have before, that appears to be hiding something underneath. That intended victim had left. The defendant goes in that direction shortly after gunshots are heard. All 3 individuals, the 2 people with the victim, were killed as well. And the police actually contacted his brother. The brother said he wasn't involved, and that not that the defendant wasn't involved, but he wasn't involved with his brother. And I don't know everything else that was brought up at the probable cause hearing. But I wasn't part of that, so I can't tell you what else they
But
had.
the footage of Mr. Way suddenly wearing the long coat, that's all from October 5. This isn't, hey, we saw him in the neighborhood 3 days before.
No, this was immediately before the shooting. The defendant left and then came back wearing the coat, appearing to hide something underneath after threatening the intended victim. And we do have witnesses. He'd been threatening to kill or harm the intended victim for some time over a disputed drug deal.
And one of the 3 deceased is, in fact, this person that you've been calling the intended victim?
Yes.
Okay. And then the other 2 are relatives of his?
Yes.
And the ballistics are 1 gun, 3 deceased?
Yes.
Okay. All right. So, Mr. Adams, you clearly need more info. It sounds like this is still unfolding, and we need to make sure that we get more of the early discovery to you. I don't know a whole lot about it either. I know enough to say that I'm not going to set a bond for a triple homicide until both sides learn a little bit more about the case. You may be able to develop something explaining where Mr. Way was if he wasn't where the video shows him right before the triple homicide. The criminal history makes me worried about Mr. Way staying out of harm's way if he's on bond. I appreciate that he had a good job, but he seems to have been involved with other stuff for a whole bunch of years, as recently as just last year, 2019. Lots of obstruction of justice makes me worry a little bit about getting him back into court when he needs to be. You can't have charges more serious than this. 3 deceased. Who's to say whether the state decides to treat this as a death penalty case, that could be in the offing. So I'm going to maintain the status quo and set no bond at this time, but I'm going to ask Mr. Pinion to work with you, Mr. Adams, or one of Mr. Pinion's colleagues to work with you to get you more information about the case so that you are not having to argue from a disadvantage of not having much information. And I am very open to reconvening this hearing after more information gets to you, Mr. Adams, so that we can talk more knowingly about why Mr. Way is associated with the case, and we'll take it from there. Any questions about that, Mr. Adams?
No, Your Honor, not this time. I would point out they did do a search warrant and no guns were found. But
Okay. I appreciate you sharing that. And please let Ms. Nelson know if the state is slow in getting you what they have. I appreciate they may not have everything either, but this was in October. It sounds like for a while the police were interested in Mr. Way. So their case is, meaning the police's case, was made by the time they were taking out a warrant for Mr. Way. So I need to make sure more of that information gets to you, Mr. Adams. And then we will reconvene to discuss this further if and when you digest that information and talk about it with your client, if you think we ought to have another hearing, okay?
all right, thank you, Your Honor.
All right, thank you, and thank you, Mr. Pinion.
Thank you.
May I be excused?
Yes, sir. All right, last one should be Mr. Lewis. There he is. Are you Mr. Lewis?
Yes.
Great. Mr. Forte, let me know when you're ready. Take your time. Okay. This is 20 CP 195695, State versus John Patrick Lewis. Mr. Lewis is represented by Mr. Hudson. Hello, Mr. Hudson.
Last but not least, Judge, I'm here. How you
Yeah,
doing?
you go from position 3 to position 7. The jail has had to navigate the logistics of getting everyone on here, and we had 2 hearings with the Department of Corrections. So thank you for your patience.
No problem, Judge, because I got a question about another case, just stylistically when we're done. So I got time.
Okay. The state's represented by Ms. McCauley, who is here in court. Mr. Lewis, do you waive your right to have your bond hearing in court, and are you comfortable proceeding from the county jail?
Yes.
Okay. And do you waive your right to have Mr. Hudson by your side?
Yes.
Okay. If you have any questions you need to discuss with him in private, let me know, and we'll move you 2 into a breakout room. All right?
Okay.
All right. Mr. Hudson, talk to me about your client and his case.
Your Honor, the alleged facts of the case is that sometime in October 2019, my client's stepdaughter, Bianca Davidson, alleges that she had been molested for a 2-year period by the defendant, Mr. Lewis. She was taken to the hospital and it was discovered that she had an STD. Subsequently, Mr. Lewis was ordered to be tested. He tested negative for STD. There is it'll be our position, there's no evidence to support that Mr. Lewis was involved in this case, that he even had intercourse with the minor child, Ms. Davidson. Judge, a preliminary hearing is scheduled for January the 8th. We was hoping to do the preliminary hearing regardless if the bond is set or not, based on the facts in the case. Your Honor, this incident took place at 5665 Deerfield Trail. That's something right off Old National in South Fulton. Judge, 7 children live in the house with Mr. Lewis, as well as his wife, Quantina Davidson. No one ever reported that Miss Bianca Davidson ever been molested or tampered with, or they heard anything. Now, what is undisputed, she's been having, difficulty, Judge, as far as I guess, her development as far as, she's been partaking in smoking marijuana, hanging out with the wrong crowd, having
Improper character.
Hold on for a sec. Ms. McCauley's objecting to you going into what's going on with the victim's life.
Right, and Ms. McCauley is right, but I was just painting a picture. But I'll move on. Judge, there's no evidence, nothing that would be able to pinpoint Mr. Lewis. His DNA is not going to be found there. There is a, based on the police report, and I'm quite certain Ms. McCauley reviewed the police report. There's a police report that stated that Mr. Lewis texted the victim and said, just know no matter what, I love you forever. Mr. Lewis meant when he texted that to the alleged victim, that's letting her know that he wasn't upset that she made this false accusation with her. He wanted to stand by her and be there for her. However, Judge, we're going to reiterate that Mr. Lewis has never engaged in any sexual activity with Ms. Bianca Davidson. Like I said, she's 12 years old. There are other children in the house that never reported that they heard anything. She always alleged that this incident took place at the home, nowhere, not in any other circumstances, but at the home. And Judge, just given that, that's why we want a more thorough flushing of the facts at the preliminary hearing. But moving on from the facts, Mr. Lewis is a lifelong resident, Judge. Like I said, he has 2 children with Miss Quantina Davidson, and the other 4, including Bianca, is his stepchildren. If he's granted bond, Judge, he would not live at the house. She was removed from the house, but and I say she, I mean the minor victim was accuser was removed from the house. She's back in the house now, Judge. So my client understands he cannot live there. He can go reside with his mother, and her name is Miss Veronica Lewis. I can provide her address, as well as his brother Kevin Lewis. They was here at my office the other day, Judge. They had to go to work, but he does have family support. Not likely to intimidate any victims or witnesses, Judge. I don't believe that he has tried to reach out to the minor child since he's been incarcerated. He has not placed any threats, and there has been no other, I guess, questionable behavior from alleged on Mr. Lewis' part by any of the other family members. The family members are unsure about the allegations, but like I said, that need to be flushed out with more facts. He's not a danger to person, places, or property, Your Honor. My client, he has a record, Judge. He was a drug dealer prior to getting a job at where he's the manager at Wendy's off Old National. He was a drug dealer, Judge, so that's where a lot of his money came from, and a lot of money also. That's where he was able to buy the house. The house that he's staying at on Deerfield, my client purchased that house for him and his family. So he's not likely to intimidate any witnesses, Judge. He's not a flight risk. No one has alleged any threats of violence to the minor child, nor his wife or other children. Likelihood to reoffend, Judge. We don't think, based on these charges, Judge, it doesn't align with Mr. Lewis's character. Now, if you want to look at his record from his past drug convictions and stuff, then you can say that he's likely to reoffend if it's drug related. But as far as this person-to-person victim crime, Judge, he's never had an aggravated assault. He's never dealt with any crimes that involve victims. Now, he have dealt with crimes that involve weapons and cocaine and marijuana. So, I mean, I'm not saying that he's a better, that one crime is better than the other, but just to say that Mr. Lewis is a threat to his own children, I don't think that happens. So evaluating our Yala factors, Judge, I think he meets the criteria for a bond. I know more facts need to be flushed out. I think a reasonable bond in the discretion of the court would be appropriate. But I also acknowledge that Mr. Lewis will be, we're going to address this via preliminary hearing. I just wanted to get a reasonable bond on the record because I instructed Mr. Lewis that we ought to go forward with the preliminary hearing, which is now set for January 8th. I don't know who will be presiding January 8th, but I wanted Mr. Lewis to know that.
Okay. Mr. Hudson, remind me again of the last name of Is it Mr. Lewis's wife?
Yes, Davidson is the victim's alleged victim's name as well as the defense
Okay.
his wife's name, and that's Davidson, Judge.
Right. Has Ms. Davidson, have you spoken with Ms. Davidson?
I have, Judge. I've spoken with Ms. Davidson. She doesn't fear Mr. Lewis. She gave me her opinion about the case. I don't think it's appropriate to share because it's hearsay.
My question isn't her opinion of the case. That's not where we need to go. It is whether she had concerns about Mr. Lewis being on bond.
She does not, Judge. But his parents, his mother, Veronica Lewis, has concerns about him being on bond, that she doesn't want him to return to that address. And even though it's his house, Judge, where he owns it, she just don't want him to come back. She'd rather for him to be away from the house because the minor child is back at the Deerfield Trail house, Judge.
Okay. All right. Well, I appreciate you sharing all that. I will circle back with you for a final word. I'm going to hear from Ms. McCauley, and then Ms. Turner may have some input as well.
Thank you, Judge. Your Honor, the state is opposed to bond in this particular matter. The child did give a forensic interview. The interview is very detailed with contextual details about the abuse that she endured from the defendant over that 2-year period of time. It involves both sodomy and vaginal intercourse, as well as touching of the child. And Mr. Hudson is correct, that child did test positive for an STI, and she was 12 years old. And she did not allege that there was anyone else that was her perpetrator other than the defendant. I think is important to note as we go through the Ayala factors. As to the first factor of intimidation of victims and witnesses, the state has concerns that releasing the defendant would put him back in the home. He is married to Ms. Davidson, allegedly, whether it's a common law marriage or a legal marriage, the state is unaware of, but they have had 90 calls between the two of them since the defendant has been in custody, demonstrating, and after the lack of cooperation from Ms. Davidson would indicate that she has already chosen the defendant over her child, which would create a situation where the child is obviously going to be intimidated and re-victimized if the defendant is allowed to be released, because he will most likely end up in the home. As to risk of committing additional felonies pending trial, this defendant was actually on probation when this incident allegedly occurred. He is on probation on 17 SC 151757. There is currently a probation warrant that is holding him in custody. As to risk of committing additional felonies pending trial, risk of flight from the jurisdiction, the state has no information to offer the court as to why he would be a flight risk other than the nature of the charges itself. And as to ties to the community, the state has no information to offer that he does not have sufficient ties to the community. I think that's very obvious that he does. But based on the nature of this particular offense, the proximity between the defendant and the victim, the proximity between the victim, her mother, and the defendant, there's a substantial likelihood of witness intimidation, and we would ask the court to deny bond at this time.
Do you know, Ms. McCauley, if there are other female children in what I'll call the Davidson household?
Yes. There are minor female children in the household. The victim does have a younger sister.
So it's 4 or 5 boys and 2 girls.
2 girls is my understanding. I'm still waiting for the DFACS records to come back, so I can get an accurate account because the mother is not cooperative.
The other daughter is how close in age, if you know, to?
I believe she's 2 or 3. She's still sleeping in a crib.
Okay.
That's true. And that's true, Judge. Everything Ms. McCauley just stated, all of that is true.
Okay. The 17 SC case that Mr. Lewis is on probation for is theft by receiving stolen property and possession of marijuana.
And possession of a firearm by a first offender probationer.
Oh, okay. I didn't make it onto the screen here.
Pled guilty on 12/20/2017.
No, not this one. He got first offender for the case ending in 757.
Oh, I'm sorry. That's 17 SC 155871. There's 2 cases.
Okay. Does Ms. Turner have information to share, or she will share your perspective, which is Ms. Davidson, mother of the outcry, the alleged victim, is not real interested in plugging in with your office?
She'll share that perspective.
Okay.
The mother of the child has been uncooperative even when South Fulton Police Department was involved in the case.
Okay.
And the child was originally placed with her grandmother, and she's been placed back in the home.
Okay. Ms. Turner, anything you want to add beyond that?
No, sir, that's all correct.
Okay.
Everything Ms. McCauley stated. Thank you.
Thank you. Thanks for staying on the call.
Yes, sir. Thank you.
So, Mr. Hudson, where does your client's mother live?
My client mother lives on Myrtle Drive, Judge. I can give you the exact address, and that's in Southwest Atlanta. I'm gonna give you the exact address. It's 1870 Myrtle Drive. That's MYRTLE. Apartment I-6, Atlanta, Georgia, 30311.
Apartment I-6 at 1870 Myrtle Drive.
Yes.
And where does Ms. Davidson live?
She actually lives in my client's home, the Deerfield Trail address.
Oh, right, the Deerfield Trail.
Yes.
And that is how far away from Myrtle Drive?
Judge, I would probably say about 20 minutes or so.
They're not in the same neighborhood.
No. Myrtle Drive is in Atlanta. The other one is in South Fulton.
Okay.
So we're looking at, yes.
One's not in Waycross and the other is in Atlanta. They are near enough, but they're not the same neighborhood.
Absolutely, Judge.
Okay.
Young, do I get a chance to make a final point?
You do. No, I'm just working through everything I've received. So here's my concern.
I just want to correct one fact for the record. I'm sorry.
Okay.
Mr. Hudson initially stated that the text message was sent to the victim after she made the outcry. That's actually not correct. The outcry was made on October 6th. The text message was sent on October 3rd.
And the text message said something to the effect of, no matter what happens.
I will love you forever.
Okay. All right. Mr. Hudson, I do want to give you the chance for the final word. Here's what I'm struggling with. It is keeping Mr. Lewis out of the child's life directly, and to me that's less complicated, but also indirectly. Mr. Lewis is free to call his wife 100 times a day while he's in jail. There's nothing wrong with that. I can't stop that. I don't think it would be appropriate. They're both adults. Adult Ms. Davidson is not the victim. They're going to talk about what they talk about. It's going to have the effect that it has on adult Ms. Davidson. Whether Mr. Lewis is in jail or not, adult Ms. Davidson is going to talk to her daughter about things. And I also don't have control over that because no one has charged adult Ms. Davidson with anything.
Absolutely.
It gets more complicated if Mr. Lewis is out because we need to work through whether he has access to any of the kids in Ms. Davidson's household, two of which are his biological children. And so I need your thoughts on that. I think you can appreciate Ms. McCauley's concern. It's my concern as well, which is how do we leave this young lady alone while this case progresses? She's got to work through a lot of things, and she and her mother are going to have their own dynamic. But Mr. Lewis needs to not be influencing that in any way other than whatever he may be talking about with the adult Ms. Davidson. So it seems to me that the cleanest way to do it is that Mr. Lewis just has no contact with anyone who is in the adult Ms. Davidson's household. But I assume she needs help taking care of all these kids, and he can help financially. But so it's complicated. I need you to talk to me about how you think it ought to be navigated.
Yeah, and I think Mr. Lewis should be granted a bond. However, I do feel that it should be either with pretrial services or somewhere a true ankle monitor is required, where he has a curfew, and also judge that he does not have any contact with, I guess, any other children pending the case. He can speak to his wife, Quantina Davidson, because I do know that they still talk while he's in jail. Against my advice, I advise him not to even talk to her, but he's going to do it anyway. I know his family don't want him to talk to his wife and everything, given the facts of this case. What I can tell you is the grandmother, the child, Miss Davison's, I guess, maternal grandmother, she has separated. She doesn't want any contact with Mr. Lewis at all, as far as during the pendency of this case, because Ms. McCauley is right. Quantina Davidson is not being cooperative at all, Judge. And alleged crime is allegedly to have occurred. So one thing I do know with Ms. McCauley sitting right there, me and her both know, based on our relationship, we're going to get to the bottom of it. We're going to get to the truth. So regardless of how you do it, Judge, I just think that precautions need to be put in place. Or even if you wanted to hold back on granting a bond, Judge, I really wanted to do the preliminary hearing first, which is on January the 8th. So.
Well, okay. I don't know that Mr. Lewis wants it to work that way. Let me tell you what I'm thinking about, and then we can talk about the logistics. I think that Mr. Lewis qualifies for a bond under the Ayala factors. These are horrible allegations. I just got through the previous one saying, oh my gosh, there's 3 dead people. How could it be more serious? And you can't compare these things. There's a terrible thing and another terrible thing. But if any of this stuff happened to this little girl, we all know she doesn't recover from it. She'll grow up and she'll do what she does, but she doesn't recover from it. So it's a permanent emotional and mental scarring that she doesn't ever get past, as much as she tries with all the best counseling in the world, if that's even made available to her. That said, bond isn't punishment. Mr. Lewis is presumed innocent, and at this point, he's merely been charged with things. And the thing that I think is the biggest risk is not Mr. Lewis disappearing, or Mr. Lewis doing something like this again, because he's not going to have kids in his life while he's on bond. It's just leaving the little girl alone. And it sounds like that falls on adult Ms. Davidson's shoulders. And the more I think about it, I guess I am in a position to say that Mr. Lewis shall not have contact with anyone in the adult Ms. Davidson's household, including adult Ms. Davidson. I think I can do that, but query how helpful that is if part of the benefit of contact is, this cuts both ways, Ms. Davidson needs Mr. Lewis's at least financial support for all the kids in the household. And that gives Mr. Lewis leverage that could be misused. But I don't want to leave the 6 or 7 kids without financial support that they need, that Mr. Lewis had been providing, bought the house they live in, and I assume other things that help them get by, and he ought to keep doing that. But that would require him to have contact with his wife. And I don't know how meaningful it would be to say, well, you can contact your wife, but it's only about financial things. You better not talk about it. We're not going to be recording his conversations. So you can see where it gets complicated. I don't think it's complicated to keep Mr. Lewis physically out of the kids' lives, and in particular, his stepdaughter. But I sort of think that's where we are. Ms. McCauley, given me telling you that I am going to set a bond, how would you structure it? Or what conditions do you think would be most effective at insulating the affected stepdaughter?
What I would request, Your Honor, would that be there's no contact with Ms. Davidson and no contact with any of the children in Ms. Davidson's household, that arrangements for financial support can be made through a third party. Perhaps Mr. Lewis's mother can communicate with Ms. Davidson. That seems to be appropriate. I think Mr. Lewis needs to be on an ankle monitor to ensure that he stays away from the residence where the victim is currently staying, with a curfew.
What's the curfew do? I heard that too. and I'm fine with the curfew. I don't see the point of it. The point is the ankle monitor. Whether Mr. Lewis is out and about at 3 in the morning or 3 in the afternoon, he needs to be far away from his stepdaughter.
I think the curfew just provides some additional structure. It's one thing to say, okay, well, you're on an ankle monitor, you can't go to this location, but I think a curfew kind of limits if the child's in school during the day, he's on a curfew during the day, something of that nature, just some structure.
Okay. Well, I'm guessing the daughter is not in in-person school right now, but I hear you. So, Mr. Hudson, I'm going to share with you the contours of the bond. It sounds like you're going to need to speak with Mr. Lewis's mother, Veronica Lewis, because I think Ms. Macaulay's hit it just right that it's going to need to be someone other than Mr. Lewis. Thank you. Conferring with adult Ms. Davidson. What's her first name?
I'm
going to say adult Ms. Davidson.
Qwatina.
Okay.
Quantina.
Mm-hmm. Quantina Davidson. So here's how the bond's going to work. Again, I don't have the complaint in front of me. I just have the calendar. So I'm assuming there are 5 counts in the complaint. It's going to be $10,000 for the sexual battery and the cruelty to children. It's going to be $15,000 for the and $10,000 for the child molestation, and then 20 each for the rape and the incest. It's a total of 70. That's what I'm setting it at. It's good bond. Mr. Hudson, I'm hearing that the sheriff's 10% program is going away. That's what I would do so that there'd be the pretrial supervision. Can I split a bond where some of it is good bond and then some of it is through pretrial?
Yes, you just have to mark each amount, whether it's good or SOB or 30.
We'll do it that way.
And just note it on the bond order.
All right. So Ms. Hansberry, since you're taking notes, I'm going to reset everything I said. So it is going to be So it's going to be 15,000 good bond for each of the first 4 counts. Child molestation, rape, sexual battery, and incest. That's $60,000 good bond. But what I see as the 5th and final count, the cruelty to children, that's a $10,000 signature bond through pretrial services, so that Mr. Lewis is subject to pretrial supervision. We'll start out at level 2. He will be required to reside at 1870 Myrtle Drive, apartment I-6, 30311. That's his mother's apartment. He will be wearing an ankle monitor for which he must pay. He must stay at least 500 yards from the Deerfield Trail address. That is where Quantica Davidson lives with the children. He also must stay away from Ms. Davidson and all the children in that household. So it wouldn't work for Ms. Davidson to bring the kids to a park that is 600 yards from their home and Mr. Lewis be there. But the bright line rule is he is always at least 500 yards away from the Deerfield Trail address. But he also may have no contact, direct or indirect, with the kids. And the only contact he can have with Ms. Davidson, his wife, is going to be through, and I'm going to leave that as a blank right now, because Ms. Hudson, you need to talk with your client, Mr. Hudson, and with his mom. I'm guessing it makes sense to have it be Veronica Lewis, who is the intermediary. But someone will be the intermediary so that Mr. Lewis continues to be able to provide financial support to Ms. Davidson and the household. But he does not do that directly. So there is no direct contact with the adult Ms. Davidson.
Your Honor, his mother, Veronica Lewis, has already agreed to that. And Mr. Lewis can attest to the fact that she has. Am I correct,
right,
Mr.
Mr.
Lewis, in
Lewis?
saying that?
Yes.
Okay, then Veronica Lewis is the go-between. And normally what we would do is say that she's the one who would arrange for Mr. Lewis to have the chance to spend time with kids. That's not how this is working at this point. There's no contact at all with any of the kids, to include the kids biologically that he had with Ms. Davidson. We may revisit that if time passes and the state's case is not developing, but for now, no contact with the kids and only indirect contact with Ms. Davidson, the mom, through Veronica Lewis.
Thank you, Judge.
I mentioned the ankle monitor. I'm not going to set a curfew at this point, but I am open to revisiting that if there are any issues or concerns. It sounds like we might hear about them through Ms. Davidson's mother. That may be how the state is learning about what's happening consistent and inconsistent with the bond. Mr. Hudson, I'll sign this bond order when you tell me to. If you want me to wait until after the preliminary hearing, that's fine. But I think we've got all the pieces in place to get it signed. It's another matter altogether for Mr. Lewis to post the bond. But I will wait to hear from you, and you should just let Ms. Nelson know, unless you know right now what you want me to do.
Judge, you can sign the bond.
Okay.
We're on board with that. Thank you.
When the paperwork is all put together, I'll sign that. Mr. Lewis, do you understand what the requirements are of you in terms of who you can have contact with and who you can't?
Yes, sir.
You should know that if the state ends up with evidence that you and Ms. Davidson were communicating directly, even if it's Ms. Davidson calling you, if there is any duration to that communication, that's going to wind you back up in jail. Now, if Ms. Davidson is calling you and you're hanging up, she's dropping the phone, that's not your problem. But if there's any evidence that there's text back and forth because you've responded to a text, or you're Instagramming each other, anything where you're responding, that's going to wind you back into custody until further notice, okay?
Yes, sir.
All right. Ms. McCauley, anything else in terms of conditions? All right. Thank you, Mr. Hudson. Thank you, Ms. McCauley.
Yeah, I got one more thing. It's not related to Mr. Lewis. Judge, I just see one of my new cases just got assigned to you on January 15th. Adonis Heard. I'm not sure if it's going to be Mr. Pena in the courtroom. It's a felony murder case. I just wanted to know, are we appearing in person or are we going to have the virtual option?
It's happening on the 15th.
Plea and arraignment on your calendar. I guess you haven't seen your calendar yet.
Right. Let me look.
Might be in trial.
No.
I got the case number for you, Judge, if you need it, just to see. You know, I don't want to talk about it. I just wanted to know, do we go?
No, I understand. What's his name?
Heard is the last name.
Adonis Heard.
Adonis Heard. 20.
Yeah, give me the case number, please.
20 SC 176859.
It's more than felony murder.
Right.
So it's plea and arraignment. That calendar hasn't been attached to my calendar yet, but you're right, it says January 15th. We have been told to make things as virtual as can be.
Good.
But I don't know that that is a Zoom day for us. If it is a Zoom day, in other words, if we're on the jail cycle for that day, then I suspect that Mr. Hurd will be appearing remotely. We are. So the calendar hasn't been added, but that morning is Zoom for us. So Mr. Hurd will be appearing from the jail. You're welcome to be here, or you're welcome to dial in.
All right, I'll dial in, Judge. Thank you, because I'll be on leave. So I just wanted to know. Thank you, Judge. I appreciate you. Thank you, Lauren.
All right. Thank you, everyone. Thank you, Rice Street, for bearing with us with our various hiccups today. We took care of everything. I'm going to end the call now.